Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate you would like to speak in order to help the chair facilitate the discussion. A friendly reminder, this is a video conference. Per Bagley King requirements, all cameras must be kept on during the duration of the meeting. If you're unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of the surroundings behind you. All committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable transcript. Thank you.
Thank you. Should we go ahead with roll call? Shannon?
Connolly?
Here.
Al-Saraf?
Here.
Escobedo? Milrod?
Present.
Alicani? Babcock?
Here.
Blakemore? Campbell? Galkin?
Here.
Gonzalez?
Here.
Huang? King?
Here.
Judge Klein? Mahoney? Morales? Pryor? Judge Rosie?
Here.
Sandville?
Here.
Smith?
Here.
And Stalker?
Here.
Okay. 2, 3, 4. 9. We have 10 present and 10 absent.
Oh, we don't have one. Sorry, Lee, give us, it doesn't look like we have quorum. I mean, can you give us a minute to see, I thought we had 11, but
Sure.
we're counting now.
Sure, let's take a minute. Thanks.
Okay, 11 present and 9 absent, and I'll go on to liaisons. And advice.
We do have quorum?
Yes, excuse me, we do have quorum. There's 11 present and 9 absent. Justice Rodriguez? Judge Wayne Gutierrez? Judge Yang?
Present.
And Selena Copeland? Lauren Klein? Melanie Snyder?
Present.
And Yoon Kim?
Present.
Thank you.
Okay, thank you. All right, let's move on to public comment. If there's anybody who wishes, any members of the public who wish to make a comment about any item on the agenda, today we'll be limiting public comment to 2 minutes. Do we have anybody that's? Please go ahead.
Hi, good afternoon. My name is Sylvia Argueta. I'm the Executive Director of the Legal Aid Foundation of Los Angeles. I am also a Legal Services Corporation grantee, along with 10 other programs in California. I want to thank you for reviewing the IOLTA and EAF applications. As you well know, this commission knows, IOLTA and EAF funding is critical. It's a lifeline for the poor in California. And providing services for the core services that we provide, which include housing, employment, public benefits, and basic sustainability, domestic violence issues, is at the core of what we do. And we hope that you continue to fund those critical programs as we are facing in 2026 major cuts to healthcare and to SNAP benefits, which are the income benefits for our food. We are bracing in 2026 for those major cuts as they were advanced in HR 1, the federal budget bill. We are already seeing cuts to healthcare from the federal administration, and our clients will be the most impacted. Legal aid at its core is ready to serve and ready to provide the needed support for people living in poverty, underserved communities. We uplift those communities, and we hope that you continue to fund those core services, which are the ones that are getting hit the hardest in the state of California. Thank you very much for your time.
Thank you very much. Do we have any other public comments?
Yes, I'll allow the next, we have two, I'll allow the next one to speak.
Hello, good afternoon, members of the commission. My name is Pavitra Menon. I am a supervising attorney at Mental Health Advocacy Services. My public comment is related to item 6.4 on the agenda. I currently supervise our mental health and care court self-help clinic. This clinic has been funded by partnership grants since 2022, and I'm here to ask the commission to strongly consider the written public comment submitted earlier this week by MHAS Executive Director Jenny Farrell, expressing our deep concern over the GES committee's recommendation to deny continued partnership grant funding for our clinic. Despite it being very similar to previous successful applications, our 2026 application didn't score well, primarily due to low marks in the innovation and sustainability categories. I asked the commission to recognize the value that our clinic has and to not follow the recommendation of the committee to discontinue its funding. Our clinic is the only self-help clinic at any mental health courthouse in the state, and it serves a unique population, namely individuals with mental health disabilities and their families. Not only do we provide necessary information regarding mental health court and care court, but we also address ancillary civil legal issues, which is something the mental health and care court attorneys cannot do. Our clinic has strong support from our court partners, and it is especially important right now given the changing landscape around mental health law and the still new rollout of care court. I also want to note that words like innovation and impact in the scoring are subjective terms, and even with the scoring rubric that might remove some of that subjectivity, the lack of context regarding how important a project is means that the people who review these applications may not be aware that defunding an existing project will have a huge negative impact on the community that it serves. For these reasons, I respectfully request that the commission reevaluate our application and consider options to slightly lower the awards for other grantees so that we can continue this critical clinic through a partnership grant. Thank you.
Thank you very much. Let's go to the next public comment.
Hello, Marilyn.
Hello. Yeah, I guess you can't see me, but my name is Joseph Carrico. I'm the executive director and directing attorney at the Yuba Sutter Legal Center for Seniors. Our request is very similar to the last grantee who spoke. We serve a very, very, very important function here in the two counties. We have been in transition since the move and retirement of the founder, and we made lots of changes, but we're still transitioning, and we've had staffing challenges since we lost our funding last year. And it won't be helpful if we aren't able to reestablish funding. I believe we're very critical to seniors in these communities. For example, I'm just going off an all-nighter where I submitted ex parte documents for an ex parte on Monday morning to keep 3 people from being evicted on Tuesday morning. And it's something you got to do. We have made lots of changes to the findings earlier, but this last time when we lost basically our auditor wouldn't perform the duties that they had contracted to. We finally found a new auditor, but we really couldn't even apply for the program until we knew that we could submit the financial statements that were required. And we just barely made it. My recollection is that our financial responsible team member, she wasn't able to upload it because our application was closed and it took longer to get that done. But we are willing to roll up our sleeves and continue to improve, but we serve a vital function. And we thank you for standing up and going against recommendations and helping something move forward.
Do you have any other public comment? Okay.
That was the last person.
Okay, thank you, Kim. All right, then we're going to move into our agenda for today. The first item on the agenda is a chair's report. I'll report to you, and Erica, feel free to jump in as well. We met last week as an executive committee to prepare for today's meeting and look at some of the items that we'll be discussing today. We received some updates on our IOLTA revenue, which is strong this year and stronger than even expected, given kind of where interest rates are. And we'll be addressing some issues today with respect to some of the matters that we've heard in public comment, and also certain recommendations from committees with respect to funding and programs. I'm excited for this next year. I think we've got a lot that we've addressed and sort of foundation set in terms of our commission and the structure and the way that we've reorganized the way committees have been working. It sounds like things are going well, and we'll get some reports from each of the committees on how things are going. So thank you all for your support and help through this process. And in terms of how we are proceeding as we continue forward, look forward to your feedback on how that process is going and how, the workload, the way that we've structured things topically, because as we've done over the past several years, we've always sort of made efforts to try to improve over time, whether that's through rule changes or policy changes or even structural changes within the commission. So looking forward to embarking on our next year now. Erica, is there anything else you wanted to add?
I think the only other just like piece of news is I think we haven't met since the Board of Trustees approved the new policy that allows us to advocate in front of the legislature in collaboration with the legislative director. So just wanted to, remind folks that got passed, which is very exciting. So as things come up and we're dealing with, grant issues, if we think, supporting a bill or something in the legislature would be good for us to do, please, feel free to bring that up, and we can coordinate with the bar's legislative director and see, hopefully that would be good for us to do. Anyway, that's all I have. Thank you. And thanks, Amy.
Thanks, Erica. All right, next item on the agenda is the director's report. I'll turn it over to Juwan.
Hi, everyone. I just want to call out if you weren't aware that this is the last meeting of the term. The next meeting begins our new term. This year, though, we actually do not have any commissioners that are yet terming off or new commissioners coming on. I'm pleased to announce that our officer appointments have been made. As you all know, those appointments used to be made by the State Bar Board of Trustees. And a couple years ago, when we were codified into authority, that now function belongs to the Supreme Court. So I'm pleased to announce that Amin and Erica are going to be staying on as our esteemed co-chairs, and Ephraim and Patience as our co-vice chairs. So we'll have our officers for one more year. So thank you very much for your service, and we all look forward to your leadership this upcoming year. The other news I wanted to mention is Xavier Vargas, who is a commissioner that was appointed by the commission. He has recently stepped down because of personal kind of obligations. So we actually have one open position now that the commission can fill off cycle. If we choose to do that, it usually goes through the executive committee and then to this commission, full commission for a vote. We are trying to see what we can do to get an appointment to present to you by November. I don't know if that's possible. And if that's not possible, then we will just have one vacancy until next year, when that vacancy will be rolled into our regular kind of appointment cycle. We've been in contact with the Judicial Council. They had some really excellent candidates this past year. So if there is a way for them to pass along those candidates, perhaps we don't have to kind of go out and do outreach. However, if you have anybody that you know through your professional networks that might be interested or a good match for this, just please contact me, and then I can see about moving them along in the process. The other update, as Amin mentioned, is a quick IOLTA revenue update for you. So since we met, the Federal Reserve has still stayed its course and has not dropped interest rates. So we are projecting a little bit better than what we have previously reported to you. For this year, when we met at the last meeting, we were projecting about $162 million for the year. Now we're revising that to about $168 million. So slightly better than what we think. So we should be able to close out the year and make our grant obligation payments and that distribution that's going to the Board of Trustees at $217 million. We should be able to fulfill that pretty easily. My next update is a LEDGE update. So as you know, this year we worked with the Legal Aid Association of California to advance a few proposals. One of them was a funding proposal to increase the amount of equal access funding. That unfortunately did not pass with the budget bill passing, and we weren't surprised. I mean, there was I would say everybody that we had talked to was supportive of it. It really came down to funding. As you all know, the state budget isn't doing well, and so there are just no funds there to fund that request. There are a couple policy bills that we also advanced that's still alive, but at this point, very unlikely that it's going to happen. So we hope to provide better news the next time, but those are still kind of making its way through various legislatures. The other update is I want to say about a month or two, I had sent an email, or Crystal sent an email notifying you about potential restriction to the equal access funding, our funds. It was a pretty broad restriction, and at the time, the language had prohibited use of our funding to serve anybody with a felony conviction. We're really pleased to say that with advocacy, that restriction is now much more narrower. So the current language now, there's still a prohibition, but it prohibits legal services defending immigrants with a violent or serious felony conviction as defined by the Penal Code. So again, not ideal, because there formerly were not restrictions on EF funding, and now we have this this restriction, though very narrow, and so we are very pleased that actually the advocacy resulted in a much narrower language. And then my last update is I do want to take a moment to kind of recognize our staff. You interact with probably between maybe 5 and 7 of our staff out of a staff of 30. And there's one particular staff, and I don't mean to embarrass her, but Kim Wormsley, you know that you get a lot of emails from Kim Wormsley. She helps with our meetings. She does your expense report. She's giving me a face right now. Kim celebrated 25 years at the state bar recently. She's been in this office the entire time. She has supported a lot of various committees. Some of them have sunsetted, some of them have peeled off to another entity. Her commitment to this work, to this office, to the commission, I just want a brief shout out to Kim, and she's looking at me right now, but thank you, Kim. So with that, I'll turn it back over to Amin.
Thank you, Duan, and thank you, Kim. That's incredible, and I'm grateful for you because you are patient with me responding to emails. And I imagine others of us have similar experiences. Kim is diligent in following up and patient with all of us. So thank you for your service for our commission and for the state bar. So the next item on our agenda was a report from the executive committee. I sort of folded that into our chair's report. So I'm going to go directly into reports from the committees. And I'll start with Jason with the grant eligibility and support.
Thanks, man. So on June 24th, GES exercised its delegated authority to approve the 2025 Care Court Awards and amounts for county public defender offices. As a reminder, the now passed Budget Act of 2025 required the Legal Services Trust Fund Commission to finalize those awards and amounts by July 1. Of the 8 applicants for a grant, the scoring team recommended 6 for QLSPs and 2 support centers for an award. The committee approved those 6 proposals, leaving the remaining funds for county public defender offices and the Office of the State Public Defender. On July 25th, at the committee meeting, we finalized recommendations for partnership grants, which are on the agenda today. And we also talked about a handful of things related to IOLTA and EAF eligibility. That was based on 3 conducted eligibility review conferences, and they'll be discussed in more detail, I believe, as well. Later on the agenda, there may be some discussion, so we're prepared to have that, but I'll kind of trail that for later. We've also had some discussion about lessons learned, which we may talk about if that comes up, about things we can think about or contemplate for subsequent cycles and how to continue to improve our approach to how we are handling it. So that's the quick update.
Great, thank you. Judge Rossi with the Program Development and Impact Committee.
Thank you. Hi, everyone. Good to see you all. So the PDI committee met on June 11th. At that meeting, we exercised our authority to approve the reallocation of the 2023-2024 HP4, the homelessness prevention grant funds. And as a reminder to folks, given our new charter, staff will have the ability to approve these reallocations going forward. So this will be likely the last time that the PDI committee undertakes that work. We also had a very good discussion of the community justice worker program. We had some folks from LAC, Legal Link, and One Justice, and we created a working group to evaluate that proposal. Aaron and Judge Yang and myself are on that committee, and we've already met once, and we're going to meet again next week. We also have our Legal Aid Justice Technology Collaborative Working Group. That's a long name for that working group, and that working group is Jacqueline and Vanetta and myself. We had our first meeting a couple weeks ago. We have our second meeting scheduled for next week. And as a reminder, that committee is reviewing the Harbor Report's findings and recommendations. Next week, we're going to talk about a work plan and timeline. What else? The Legal Aid Data Project Advisory Working Group is also set. That's also Aaron and Ken. I think they met this week. Staff's been analyzing and synthesizing the data from the last 5 years and examining data from the 46 legal aid providers that participated in the 2019 and 2024 Justice Gap studies. So that working group is moving along. And then we also have a team that's looking at the changing policy landscapes. That's Efreen and Ken and Maria. And that's about creating an impact brief on how the shifting public policies are impacting our grantees, which we've heard a little bit about already. The brief will serve as a resource for us and for grantees moving forward. This is a thought partnership of a series of folks together. So we'll have some touch points between the grantees and our commission moving forward, and really working on assessing changes to housing, immigration, rural justice. Also, this would cover the conversations we've had about preparing for natural disasters moving forward. I think that is everything that we are doing, but if Chris, if you're on the phone and I have forgotten something, I think that's it. We have quite a few things we're working on. And then we'll meet again later this month, at the end of this month. And Aaron, if you have anything I've forgotten, please feel free to jump in as well. That's it, Amin.
Thank you for the update. I'm going to turn it to Catherine for an update from the Rules Committee.
The Rules Committee, the first item is actually on your agenda today, which are the financial rules that are on the consent calendar. But this work was actually done by the prior Rules Committee, and I just wanted to acknowledge Erica Connolly and Jason and Patience and Jonathan and Jacqueline, who just left the room. But this was a really big undertaking and complicated intersecting items, and I think they've ended up in a really good place. So just wanted to express an appreciation to them and the staff that did all of the amazing work on that. We continue to work on support center topics. We will meet again at the end of the month to talk about kind of the second group of those. We did the first group at our prior meeting. Our staff is getting comments from support centers sort of conceptually about them, which will be helpful. We will also take up at our end of the month meeting a grantee investment policy, so we can be clear about what grantees can and can't do with investing funds. And then hopefully at the October meeting, take up real property purchases, which the Office of General Counsel is working on. So that is our very quick update.
Great. Thank you, Catherine. Okay, next item, we've had our May 21 minutes from our May 21 meeting that were posted on the website. Does anybody have any changes or questions or comments on those minutes? And if not, do I have a motion?
Catherine moves approval.
Catherine moves. Second?
I'll second.
Jason seconds. And let's do a roll call vote.
Alikani,
You stepped out.
Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Galkin,
Yes.
Gonzalez,
Yes.
Hoang, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sanville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Escobedo, Milrod,
Yes.
Alsaroff,
Yes.
and Connolly.
Yes.
13 yes, 0 no's, motion passes.
Oh, and Jacqueline is back in the room. We're just doing the minutes.
Is it too late to vote yes? It's okay.
Jacqueline votes yes if you would.
14 yeses.
Terrific. Okay, the next item is the consent calendar. There's going to be one item that we're pulling off of the consent for discussion. And I think so that's going to be 5.1. And I guess procedurally, should we go ahead and have that discussion first and then do the consent calendar?
That's the only item on consent, Amin. So I think we'll just pull and then Erica Carroll can do the update and then we can start.
Okay, Erica?
Yes, good afternoon, everybody. Thanks for taking a few moments to talk about this item. 5.1 is the approval of proposed new and revised rules, the return from public comment, and a recommendation to the Board of Trustees for the rules that Catherine mentioned in her update. The reason I asked to address you is we came across a technical issue that when we were preparing these materials for the meeting, we noticed that there were two questions where none of the commenters had entered a response. And so we decided to look into that further to see if that was purposeful or if there was something wrong with the survey logic. And what we determined was that there was a technical issue with the survey. So there was a question about whether the person commenting was an attorney or not. That wasn't visible to commenters. And then there was a question related to the commenters' position on unspent and relinquished grant funds, whether they agreed or disagreed with that rule proposal and any comments they might want to add to it. So that was also not visible to commenters. We received 9 comments overall. The way the survey is designed, commenters could see the rule proposal. So that is not in question. They could see the rule that was released. There just wasn't a separate comment box for unspent and relinquished grant funds. They could have entered comments on it in another part of the survey form. They could have submitted a letter. So there were options to submit comments. We didn't receive any, but we did want to raise it to your attention to, assess whether the commission feels that recirculation for a public comment would be appropriate under those circumstances. Juan and I have talked about it and feel that there probably was sufficient opportunity to raise concerns about that rule if commenters wish to do so. But we do want to, in the spirit of full transparency and assess your feelings about whether this complies with the spirit of the public comment process.
We also did check with OGC and they feel comfortable too. Raul's here. So we feel comfortable, but we wanted to flag it for you out of an abundance of caution in case you would like us to resend it out for public comments.
So I just want to clarify, if I'm understanding correctly, nobody's right to comment has been impaired. The subject matter on which we're soliciting comment was available to everybody, and the technology didn't prevent anyone from submitting a comment with respect to any of the proposed changes. Is that correct?
Yes, it's correct that the proposed changes were available for review. They could have submitted comment on that rule elsewhere in the response, but there was not the separate question that specifically said, how do you feel about unspent and relinquished grant funds? That was not visible, but had they wished to comment on that rule, they could have entered it elsewhere on the form.
And the entire memo is available. So the memo,
yes,
similarly to your packet of material, that very lengthy memo is available to them and was visible.
Okay, well, when it becomes appropriate, I would move adoption of these recommendations.
Okay,
I'm sorry, I'm having some difficulty hearing whoever was speaking.
That was Patience. I can restate her question. It would be helpful.
Sure.
She was asking about whether the technical error or issue prevented anyone from seeing the content of what was to be commented on or having an opportunity to comment on the same. And I believe both Juan and Erica confirmed that while the specific pointed question and survey mechanism referencing that material had the issue, the overarching material was present and available, and there was a space for open-ended comment for any of the material that was available. Hopefully you all agree that's a fair summary.
Thank you for that, Jason. Does anybody else have any thoughts or comments on this issue? It sounds like there was opportunity. It sounds like the spirit of public comment and the mechanism of public comment, while maybe not comprehensive in terms of specifically asking the question. There was opportunity for anybody to provide public comment on those items. That those were met. So it sounded like Patience was making a motion, or I suppose we should do it.
Yes,
Making a motion
But I
to.
tried to do.
Yeah, thank you, Patience. A motion to go ahead with submitting the proposed new and revised rules, make a recommendation to the Board of Trustees. Is that correct?
Yes.
I'll second the motion.
And Erica seconds. Let's go ahead with the roll call vote.
Alikani,
Yes.
Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Galkin,
Yes.
Gonzalez,
Yes.
Huang, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Escobedo, Milrod,
Yes.
Al-Saraf,
Yes.
and Connolly.
Yes.
14 yeses, 0 nos, motion passes.
Okay, thank you. All right, let's move on and into our next agenda item, which is a progress update on the 2025 Trust Fund Commission Implementation Plan, and I'll turn it to Joyce.
Great. I'm going to share my screen because I have a short presentation. Can everyone see that? Good afternoon. It's wonderful to see you all. I'm here just to give you a update on our progress on the implementation plan that was shared with you all, I think in February of this year. I think I don't know if you've seen the accompanying materials, but those materials will give you some details on all the various activities that the team has embarked on in the first half of this year, which hope you will agree are pretty extensive. And so I'm just going to give you a little bit of a high level kind of overview of what we've done. But again, those materials would be worth looking at if you want to get into the details of the work. So very high level, we are hitting all of our marks and we're on our way to hitting all of our marks. We've got green check marks against all of the strategies that we are trying to achieve. So these strategies are pulled from your strategic plan of 2024 to 2028. I will just want to highlight that there was a slight change in strategy 3. We did one pivot relating to veterans legal services, where after some work with the working groups, our stakeholders identified that actually the original focus that we had identified was something that they weren't actually wanting to prioritize. And so that was shifted based on feedback from the folks that we were working with, which I think is a great reflection of how strategic plans are meant to be working, right? They're iterative and they respond to kind of ongoing needs. So our team has done a really good job of kind of pivoting as and when. But overall, across all 5 strategies, I think we're hitting all of our targets. I just wanted to point out a couple of key accomplishments. Again, these are just a handful. If you look at the accompanying materials, you'll see the kind of breadth and the depth of the work that our team has done. I mean, all of these things should not be new for you. I know you've heard them in various committee meetings or commission meetings, but maybe I can touch briefly on them so we can take a moment to celebrate kind of accomplishments that we've hit over the first half of the year. We have developed a number of new fact sheets for legislature and private funders actually who are interested in seeing kind of the data that we had pulled around the federal landscape. We've also made these fact sheets available to all of our grantees on our Smart Simple platform. We've launched a number of working groups, many of which you all have joined and participated in and are familiar with. So they include our Legal Aid Justice Tech Collaborative, our Community Justice Workers Working Group, our Legal Aid Data Advisory Working Group, and our California Legal Aid Interagency Roundtable. I know you're going to be hearing maybe from a couple of these initiatives, either in this meeting or in following meetings, or have already heard from them. We've released the 2024 Justice Gap Study. We'll certainly be hearing about more of this later. It's very exciting. And that will be used to develop an outreach plan to increase and incentivize pro bono attorney participation. A number of rule changes recommended, and as Catherine mentioned, this does take a lot of work and investment by you all as well as staff. So kudos to you all in kind of pushing forward that work. And our team has also held multiple trainings and convenings for grantees. So help them build knowledge around various grant applications, which, as we know, are incredibly complex and hard to get your head around, especially if you're new and even if you're not new. So I think those have been really well received by grantees and hopefully makes the process a little bit more seamless. And of course, we have administered and continue to administer special session, Equal Access Fund grants, and our CalHFA 2.0 grant, which I think you'll hear more about later today. Any thoughts?
I was just intrigued by, you said you pivoted on the veterans work. And
Yeah.
so maybe you could remind us what it was initially. I don't recall.
Oh, sure. And
what
I
it is
can,
you're doing now.
yeah,
That'd be great.
yeah, absolutely. So I don't know if Kim Turner is available. She could probably provide a little bit more. Oh, she.
Yes, thank you.
Oh, great. Wow, that was fast.
Hi, Joyce. Thank you. I think I heard Catherine speaking. Kim Turner, Senior Program Analyst with the Office of Access and Inclusion. Really appreciate this chance to share with you and the overview that Joyce shared on veterans. I'll quickly share that, and we worked with Elizabeth Hom, Abraham Gutierrez, and several other teammates on our veterans work through the years. We're really excited to be further refreshing and updating our veterans legal services work as we've done all along. And in that context, we were looking into the availability of accredited representatives for veterans legal services. It's a special type of representative that helps veterans with discharge upgrades and other benefits related claims that only an accredited representative can conduct. And we did some research about that, and we talked with legal services providers in California, and we were wondering if we needed more accredited representatives to help veterans. And of course we do, but we learned in our discussion with groups that they more wanted other resources and other sort of bandwidth expansion around areas like family law or areas like actually eviction defense, that veterans often experience. So rather than go in the direction of work more on accredited representatives, research and bandwidth expansion, we're pivoting to a broader inquiry on how we can help our legal services orgs better serve veterans. That's not just including accredited reps. So that was the pivot. And of course, if others want to chime in on that, I know Chris and Joyce and others and Elizabeth have been very helpful with our veterans work. Thank you.
Hi, this is Elizabeth at Hum in San Francisco. I just wanted to add to Kim's quick update that we will be hosting.
Yeah. Can you hear us?
Seems to have it under your hand.
Sorry, they're fixing my mic. So I just wanted to add that in addition to Kim's great report out, we are hosting a convening related to veterans legal services late in September, where we're inviting grantees, but also some other stakeholders in the veterans space as a roundtable, just to begin additional conversations to inform this work. So thank you.
Yeah, Joyce, two things. One, you mentioned in the prior slide that there were 5 new fact sheets that the office had developed, and you made those available to grantees through Smart Simple. Are those otherwise available, say, to us as members of the commission? Since we're not on Smart Simple, at least I don't think we are, at least I'm not anymore. how do we get those fact sheets? How do other groups say, like LAC or the Access to Justice Commission, how do they get access to those fact sheets?
Well, we can certainly share them, and I'm sorry that you haven't received them already, but absolutely, we can make sure that you get access to all of those fact sheets.
Great, thank you.
We'll make sure we
one
send
other
those
thing,
to you.
so you talked about the issue of pro bono and increasing and incentivizing pro bono. So Judge Rossi mentioned in her PDI committee report that the legal aid data working group met this week. It did meet this week. And one of the things that we talked about was the fact that looking at the data from 2024 compared to 2019 data, you can clearly see that the number of pro bono lawyers who have participated in work has increased, while the number of pro bono hours has decreased. We're talking about how we could discern why that is. And sort of the feeling was it is probably because more lawyers are doing clinic type work than extended representation type work. But we asked the question as to whether or not that was supported by data, and that data is not captured. And the whole purpose of the legal aid data working group is not to create new forms of data and more burden on programs, but to try and streamline the data that we're requesting for programs. But you may want to look, and when you look at that pro bono issue, you may want to sort of drill down a little bit more with some of the pro bono grantees who are specifically focused on pro bono more than other programs are, to try and figure out what it is that's going on with pro bonos, given that lawyer numbers are going up, but lawyer hours are going down.
That's really helpful feedback. I appreciate that.
May I add something?
Yes.
This is Danielle McCrae, lead program analyst. I'm only chiming in because I'm working on the pro bono strategy for our office generally, or helping with it. I don't think we have data that's grantee specific, so I think that's super interesting. I do know that ABA pro bono survey has some questions around what types of services attorneys are providing when they do pro bono, so that might be an opportunity for us to tease out. Do we see there that they're providing, for example, more clinic hours or like smaller shorter term services, advice and counsel rather than full scope rep? That might be a data source we can dig into that we have some access to.
Yeah, we also have the new reporting requirements for pro bono, which are somewhat minimal at this point, but it might be worthy of thinking, like, are there additional questions that ultimately want to be proposed for that survey? And I don't know, I'm not saying it's the right time to do it right now because we just need to get people to report something, but it may be a useful source to kind of really understand from those attorneys' perspectives what kind of work they're doing.
Yeah.
Aaron. Yeah.
Go ahead.
Hi, thanks. I have a question going back to the fact sheets, and thank you so much for creating those and making those available to some key stakeholders. I was wondering, to Ken's question, is there a plan to make them broadly available to the public? I imagine they might be helpful for two kind of public-facing reasons. One, to help narrow the knowledge gap potentially about what legal services can do to help people solve their life problems or address some of them. And two, to just help build public support for legal aid, which will kind of back up our legislators, who I know you did communicate these to, but give our legislators, more confidence maybe that the public is really behind legal aid.
I could take a stab at that, Joyce. In your strategic plan, there is a strategic plan around communications. So one of the discussions in February was how do we bolster that? So one thought that we will be exploring is the State Bar is going through a website redesign. So once that happens, the landing page for our section, the Legal Service Trust Fund Commission and the legal aid, we're thinking that might be a great way to kind of curate and put some of this information on. One other thought that we've had internal discussions about for several years is there a way to do kind of like a dashboard for the state of California, breaking it up by counties, and then if you zoom in, you can see like not only the amount of funding that we have there, the providers, the amount of services that have been provided, the outcomes. If there's some easy way to like have some interactive type of platform, that's the hope. That's like a long-term goal, but that's the plan, Aaron, is to have it accessible, and then curate, because there's a lot of data points right now, and this is part of what the data working group is being tasked with, like what data is necessary and what data is not necessary, and then how do we get that kind of more visible.
Yeah, thanks, Ron. I think that makes a lot of sense. And I mean, the fact sheets that presumably you've already kind of curated down what data points are easiest to communicate in a one pager, maybe low hanging fruit before, the whole data project is complete and all of that. I hear that's a longer term thing, but those fact sheets that you already have are great. And I think it would be great for the public to see them. So thank you.
Yeah, we will try to, maybe we can expedite that and have those maybe on the website sooner. And then we'll send it around after the meeting, the fact sheets. And if you have any feedback on them, please let us know. We've been trying to have like different iterations because different stakeholders have different like focuses. So we have like a template and then we modify it based on if it's a philanthropic foundation, or if it's a certain, sometimes it's just legislation wants a statewide picture, or sometimes it's a certain legislative area, like account, they'll reach out to us and then we'll make something really specific. But yeah, we'd love your thoughts.
Thank you. Any other comments or questions for Joyce or for?
Let me just quickly touch on some of the projects that we have in progress. And again, these are all things that you are already familiar with and have already been discussed. So, our team is developing this impact brief. You've heard Judge Rossi talk about that already today. We're heavily involved and invested in our legal aid data project initiative, which is a very long-term project. We're working with our research team at the State Bar to review and analyze data that we've collected over the last 5 years. And there's just a number of various working group meetings with lots and lots of stakeholders, nonprofits, grantees, government, agencies, you all, staff, across a variety of different subject matters. We're pretty diligent about surveys as well. So again, any opportunity that we can collect data and feedback around various things, whether it's kind of our grant, the grant application process or the grant itself, or to help shape our own strategic plans and work plans. And we still have a lot of grantee trainings scheduled for the rest of the year that, orienting around the feedback that we have collected already about what people need. So those are just a few of the things, and definitely, again, if I can encourage you all to read the document that is on the agenda, just to get a fuller sense of everything we've done so far, that would be great. We'll be back again probably at the beginning of next year to give you a full year's accounting.
Perfect, thank you. And this is again consistent with kind of our growth and improvement. Is to sort of keep ourselves accountable and also celebrate the things that we've been doing, which is something that we should be doing more, because there's a lot that we're accomplishing among our group and with staff and everybody kind of plugging along at full speed. But Erin, it's a great point. Communications is something that I think we've struggled with as a commission and as a program for a long time, and there is a lot to share. There's a lot to do, and we can start small and grow out, but the goal would be something along what Dewan said, just to have something that's built out and readily accessible, readily populated with things that are really important for our stakeholders, but then also for the public and for the legislature as well. Okay, let's go on to the next item on the agenda, which is approval of recommendations regarding 2026 IOLTA and EAF applications. And I'm going to turn it over to Angela.
Yes, so 6.2. So good afternoon. I'm Angela O'Hara, a senior program analyst, and I'm happy to be presenting on this topic along with Erica Carroll, who I already spoke, but she'll be chiming in a little bit later. The focus of today's discussion will be on issues that require commission approval, some of which, like Jason mentioned, have already received a recommendation from the GES committee. But so our topics include an overview of 2026 IOLTA EAF application process, support center deeming results, audit extension requests, primary purpose and function, eligibility review conferences, ultimate eligibility recommendations, and then the pro bono allocation. So we've got quite a lot that we get to talk about. So it's going to start first with that overview of 2026. let's begin with the fact that our office received 120 applications for IOLTA and EAF funding. 97 were for qualified legal services projects. 23 were for support centers. Currently, we're at 119 because one organization recently withdrew. 114 were renewal applications. One application was from a longtime grantee who did not receive funding in 2025. 6 applications were for first-time funding. California Center for Movement Legal Services, California Immigration Project, Caracen Dependency Legal Services, Pangea Legal Services, and United Farm Workers Foundation. Of the new QLSP applicants, 4 of the 6 had a primary focus on immigration. 1 was on juvenile dependency, 1 on systemic advocacy, which was a combination of impact litigation, policy advocacy, education, and direct legal services. So applications were received way back May 15th, and staff has spent the last 2+ months reviewing applications, requesting revisions, providing technical assistance to get us to this point. Staff made recommendations to the GES committee in May, June, and July, which makes recommendations, as you all know, to the full commission for a final determination. So once the commission approves eligibility, staff will run the IOLTA formula and release to applicants their tentative award allocations for 2026, as well as budget proposal forms. And then the GES committee is scheduled to meet on October 30th and will discuss any substantive issues related to budget proposals at that time. Okay, so that was our first topic, the overview. Now, support center deeming results. So a quick update on the outcome. To be found eligible for IOLTA EAF funding, support centers not in existence as of December 31st, 1980 must be deemed to be of special need by a majority of the qualified legal services projects. Our office practice is conduct a survey every 3 years. The ballot was sent to current year QLSP grantees. There were 89 of those. The Center for Gender and Refugee Studies was the only support center up for deeming in 2026, and they achieved a majority vote in support. 69 of the 89 QLSPs responded. There were 62 yeses, 3 nos, 20 non-responses that counted as a no, bringing that to 23 no's. So that was a 78% response rate and 70% of all QLSPs voting yes. So that is support center deeming, just a quick update there. Now we're on to audit extension requests. So a reminder, an audited financial statement from the fiscal year that ended in the prior calendar year is due from every applicant for IOLTA EAF funding by May 1st. Staff review these audits to confirm gross corporate and qualified expenditures as part of the IOLTA EAF application review. And as I'm sure just a reminder, but important, staff has discretion to grant extensions through the application deadline, which was May 15th this year. But beyond that application deadline, the commission can grant an extension to submit the audited or reviewed financial statement upon a showing of extraordinary circumstances. If none are present, the commission may grant such extensions with conditions. So at the May 7th GES committee meeting, the committee recommended approval of 3 audit extension requests that were submitted by applicants up to that point. And the commission approved those at its May 21st meeting. Then at the June 24th committee meeting, staff presented 4 additional audit extension requests, which you see up on the screen right now. So they were the Wage Justice Law Center, citing unforeseen family medical issues and heightened operational demands. Public Law Center, noting executive leadership had experienced a death in the family and there were some unexpected medical issues. United Farm Workers Foundation was unable to close out a federally funded program, and that was impacted by USDA restructuring, and that was the reason for the delay. Yuba Sutter Legal Center for Seniors cited its initial delay as due to an inability to comply with auditors' changed terms of agreement that required CPA to formally close books prior to the audit process. However, after learning its organization's size permitted a financial review instead of a full audit, they engaged a new accounting firm to complete that process. So just a note of what has happened since. Wage Justice Law Center, Public Law Center, and United Farm Workers Foundation submitted their audits by the requested extension dates that are shown up on the slide. Yuba Sutter submitted, excuse me? Sorry, I was on a roll. Was there a, okay, it was an accident. Okay. Slow me down if I'm going too quickly. Yuba Sutter submitted a reviewed financial statement on July 26, 2025, and then sent a corrected financial statement on July 28 after noting an error in the original submission. Further, at its June 24th meeting, the GES committee found the requests from Wage Justice Center and Public Law Center had demonstrated extraordinary circumstances that would result in anticipated delays, and they recommended granting the extension requests through the requested extension dates. For the United Farm Workers and Yuba Sutter Legal Center for Seniors, staff had identified some additional grant eligibility issues that existed and recommended eligibility review conferences with each organization. So the UFWF eligibility review conference team found later that the request demonstrated extraordinary circumstances and recommended approval. So I will present the proposed resolution on the next slide, but just one last note is that the ERC recommendations about these additional remaining issues, we'll be discussing those a little bit later. So first, there will be a proposed resolution that is related to these three organizations that have, so this is only about the audit extension requests for 2026 IOLTA and EAF for Wage Justice Center, Public Law Center, and United Farm Workers Foundation.
And they've all now submitted their
Yes.
audits, so.
Okay.
Okay.
They all have submitted their audits and they've all been received. So that's your first item.
Thank you, Angela. Do we have any questions or any motion on the resolution that's on the screen?
I'll move the resolution.
I think,
A second.
I think Erin has her hand up.
I'm sorry, I second this resolution. I have a question about Yuba Sutter. So I'm seconding Angie's proposed motion here.
Okay.
Yeah,
Before we do a
my-
call vote, it sounds like we have a comment.
And
Or-
just a question also about Yuba Sutter and whether is there a separate resolution with respect to that organization? So we're just doing these three in this resolution, is that correct?
Yes, that one's more complicated, so
Okay.
we're going to table that. We'll get to that with a full discussion on that.
Got it, thank you.
So this is Erica. My question is somewhat related. Is more just like a nit. The resolution right now says, and it is, and nothing after that. I assume there's probably a further resolved, but if we're just going to do these one at a time, maybe we could just take that part out and put a period at the end of foundation.
Oh, I accept that as an amendment.
Thank you.
It's a great idea.
All right, so with that amendment, should we go ahead with the roll call vote?
Alakani,
Yes.
Babcock,
Abstain as to Public Law Center, yes as to Wage Justice Center and United Farm Workers Foundation.
Blakemore,
Yes.
Campbell,
Yes.
Galkin,
Yes.
Gonzalez,
Yes.
Huang, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Escobedo, Milrod,
Yes.
Alsaroff,
Yes.
and Connolly.
Yes.
That's 14 yeses, 0 nos, 1 abstention. Motion passes.
Excellent.
Great.
Let me continue my role. So the next topic, and this is a primary purpose, which the GES committee voted on at its 7:25 meeting. So, so I'm just going to provide a brief update at this time.
Are we on to the last grantee that wanted an audit extension?
Not yet. We'll get
We're
to that in
skipping
one.
that
Yeah,
for a moment. Okay,
we're
just
gonna.
like
Yep.
Trying to.
I hear you. Okay. One moment, and we will get to eligibility review conferences, at which time we'll bring up the 3 eligibility review conferences, and that grantee was a member of that. So, but primary purpose and function, this is just an update. A reminder to qualify for IOLTA EAF funding, a QLSP must have a primary purpose and function of providing civil legal services without charge to indigent persons in California. And under the state bar rules, applicants with 75% or more of qualified expenditures toward this purpose establish a presumption of eligibility. But if an applicant is below that, they may still apply provided they can satisfactorily demonstrate they meet the requirements by other means. And historically, the commission has found it possible for organizations between 50 and 75% to establish primary purpose, but they take a closer look at these applications. So we had 2 QLSPs, not including those with ERCs, which we will turn to next, which fell below the presumption. And so I just want to share with those briefly. They were the Family Violence Law Center, who was applying in Alameda with 57.7% of QEs toward primary purpose. So this organization provides legal services and policy advocacy, crisis intervention, and youth services. It's a longstanding QLSP with a holistic services model that has brought them below 75% for many years. However, their services and explanation have really remained consistent. They're the only domestic violence agency providing these connected legal services. And then the other one was Pangea Legal Services, applying in Alameda, Contra Costa, San Francisco, San Mateo, and Santa Clara. And they had 74.4% of QEs toward primary purpose. This was a first-time applicant providing immigration legal services, very close to that presumption of 75%. And their reasoning is there was a horizontal structure that requires all staff to spend time in administrative and fundraising. And so that's one of the reasons why they had so much more toward admin and fundraising, but they're committed to hiring more dedicated admin staff, which will presumably help them exceed 75% in the future. So those were 2 that I just wanted to brief you on.
Can I just ask one question?
Yes.
Is there also a limit on admin expenses, I think? A threshold, right?
Yes, well, I don't know how to answer that
I can help.
articulately in this moment, please.
I can help. So I don't know if this is exactly what you're asking. So we do allow programs to claim admin for both IOLTA and EF. It's certainly more flexible on the IOLTA side. For EF, that admin has to be related to the set of activities that are proposed for the EF funding. For IOLTA, they can claim general admin funding. They have to prorate it if their organization does, say, non-legal services or non-qualifying work. But generally, the fundraising does count. And then at the budget stage, when programs are doing a budget for what they want to use our money for, there are like there are percentages that they have to kind of meet that doesn't trigger extra review. So there are, in that instance, there's like an admin versus non-admin. So if they stay within a 75-25% threshold, then that's fine. If they deviate from that, it doesn't mean it's not fine, but we take a closer look at that. And if it's questionable, then we elevate it to the committee to review. So I know that's a little bit more information that you might need, but I hope
That's helpful. It reminded me where the percentage came into play. So thank you.
Thank you, Tuan.
I have a question too. This is under the primary purpose and function page where you mention QEs below 75%, and you mention that they meet the requirement by other means. And what are those other means? Can you tell us a little bit more about that?
Yes. One moment while I pull up unless one of my colleagues has the eligibility review guidelines that describe more fully what.
I can help with that. So usually that other means kind of prong is a little bit of a catch-all. So say, and this is where the kind of the office practice has evolved over the year. If they're less than 75%, they don't meet the presumption. So they have to kind of present to you additional information to kind of prove that they do meet primary purposes. The majority of their work is for free civil legal services in the case of QSPs. But over the years, it's kind of evolved in that they, between 50 and 75, you all approve. There was one incident a few years ago where there was an existing program that dipped below, barely dipped below. I want to say it was at 48 or 49%. However, they did present additional information to say that for that, just that year, there was a particular expense that they had to discount that we we had, it was required, but it was only for that year. So for that 1 year, you all approved them with a 49%, but that's the only time the commission has dipped below 50%. But you have that provision in there, kind of in other means, in case you want to exercise a little bit more discretion.
Yeah, and if I can just jump in on that as well, the other means is, I think, purposely sort of open-ended. It allows the organizations through their narrative response to provide the information that they think is most salient to justify their primary purpose. And so what Angela presented is a brief summary of what was contained in those explanations, but they do provide more lengthy narrative about how they meet the primary purpose requirement, either like for, in the example of Family Violence Law Center, talking about their holistic services model and why these other services are relevant to the effectiveness and of the legal services component. We're talking about things like their public programming, their articles of incorporation, their annual reports. There's a lot of different options for grantees to provide that justification for consideration and review.
Thank you. Is that helpful?
That's helpful.
Okay. So that one, I was only going to provide an update. There's nothing to vote on. And our next topic would be eligibility review conferences. And that one, I will turn it over to Erica to be your guide.
Thank you. So moving on to eligibility review conferences. For those who might not be familiar, these are meetings that are typically held during the application review process, although we have had them at other times of the year as necessary when questions or concerns arise that would require additional time and analysis regarding an organization's qualification for the IOLTA and EAF grants. It provides a direct line from the applicant to the commission, which is facilitated by staff, and allows an opportunity to go in depth on eligibility questions in a way that you wouldn't with just the application review itself. So it's not uncommon, in particular for new applicant organizations, to participate in an eligibility review conference, and this would be primarily due to their lack of familiarity with the grants, with the governing authorities. It is a very detailed application process that they've never had to go through before. Staff are not familiar with the organization, and so there's often, it provides another touch point essentially in this process to learn more about the organization and ensure that the information we have is sufficient to make a determination on eligibility. This year, we had 3 organizations participate in eligibility review conferences. That was Dependency Legal Services, which is a new applicant, United Farm Workers Foundation, also new applicant, and then Yuba Sutter Legal Center for Seniors, which is a currently unfunded applicant, but a former grantee. Recommendations from an eligibility review conference are recommendations of commissioners who participated rather than a staff recommendation. The first eligibility review conference that I'll go over was Dependency Legal Services. So as I mentioned, they are a first-time applicant applying as a qualified legal services project. They applied in 5 counties, and there is a requirement under the statute. So let me back up. Under the statute, if an organization receives Legal Services Corporation funding or Older Americans Act funding, they are presumed eligible for this funding as well. the vast majority of our QLSPs do not receive either of those funding sources. And so the third way that an organization would qualify is by demonstrating additional monetary support and demonstrated community support for the operation of a viable ongoing program. And under our eligibility guidelines, the way they would typically establish this is through $20,000 or more in funding from local funding sources from community in their immediate surrounding community. Most of our grantees meet this requirement, and that's how they establish that through the $20,000 threshold. In the case of dependency legal services, they did not meet that threshold, and so the eligibility guidelines allow them to have a non-cash demonstration of local support, but this is not a scenario that comes up very often, and so it was determined it would be appropriate to hold an eligibility review conference to have the commission weigh in on what would be satisfactory evidence of community support. And so the organization receives most of its funding from contracts with the Judicial Council or state or other federal funding. But they were able during the eligibility review conference to detail their relationships with local courts, the involvement of judicial officers at the county level for the contracts that they receive in terms of selecting them as a recipient of contracts for juvenile dependency work. They work with other legal nonprofits to obtain education law services or immigration law services for their clients. And they partner with other nonprofits in the community on things like parent mentor programs. And so throughout the ERC, they were able to articulate these various connections and collaboration opportunities with other institutions and organizations in the community where they work. And so the eligibility review conference team was satisfied, and the GES committee concurred with the finding that dependency legal service had sufficiently demonstrated community support and recommended them as eligible for funding. The second eligibility review conference was with United Farm Workers Foundation, also a first-time qualified legal services applicant. They're applying in Kern, Fresno, Monterey, and Ventura counties, and they provide both legal and non-legal services to farm workers and immigrant workers in the program areas of community advancement, legal immigration services, outreach, education and organizing, communications, systemic change, and they also do some one-off or one-time programming and administer pass-through funding. So the question that arose in relation to United Farm Workers, in addition to their audit request for an extension that Angela detailed, the other major question with respect to this organization was an exploration of their qualified expenditures percentage. So their final qualified expenditures percentage came in just shy of 60%. And so the question was whether this would meet the primary purpose requirement. There were also questions about whether the organization had accurately deducted their non-qualifying activities, whether their public-facing materials aligned with activities described in the application, because there appeared to be a bit of a mismatch there, and whether they had an appropriate methodology for calculating qualified expenditures and then applied it correctly. Given the low qualified expenditure percentage, this is something that the commission would have to make a determination on for primary purpose. During the application review process, staff provided a significant amount of technical assistance to this organization as a first-time applicant, which led to various rounds of revisions and quite a wide variety in the organization's qualified expenditure percentage. So when the application was first submitted, their QE percentage was 25%. And then after some revisions and discussion and TA from staff, it went up to 71%. They made subsequent revisions that brought it to 46%. And then the final revision brought it, as I mentioned, to just below 60%. So going into the eligibility review conference, staff's recommendation had been to seek more information from this organization to clarify some of these points about, for example, their understanding about the distinction between qualifying and non-qualifying work and how they were applying that to their expenditure calculations. During the eligibility review conference, the organization did provide details and examples of its legal and non-legal services. For example, they mentioned that they deducted all of their out-of-state work. that their staff, both their legal and non-legal staff, track their work by time. So they had applied a pro rata share to their work to determine the expenditures that were non-qualifying. They also mentioned that they have tags for their social media posts about what's legal and non-legal, so they could pull out that information. They do have a large staff. I believe it's about 91 staff, but only 5 of those staff are attorneys. 23 are classified as paralegals. I believe 12 of those 23 are accredited representatives to provide immigration legal services. They have 22 clerical and admin staff and then 41 other staff. And so they talked about the legal services component of their work, and also talked about the variety of other services they provide that are important to the community, as well as the reason for having public-facing materials that their audience is different, right? They're not advertising to a funder with their public website, they're advertising to their client population and constituency, and that they wanted to be sensitive to the needs of the community and build trust. And so some of the information or the framing of what they're sharing on their website might differ, but that there was no discrepancy between the services that they're actually offering and what was detailed in the application. So as I mentioned, going into the eligibility review conference, staff had raised the question of seeking more information from this organization to confirm that its methodology was correctly applied and that the organization had an understanding of the definition of civil legal services in order to sort of graft on that methodology correctly. During the course of the ERC, the participants in the ERC felt that the information that was shared there was sufficient. And so no more information was sought from the organization after the ERC. We have received questions or anecdotally heard concerns about that from the community in terms of being confident in the percentage, the QE percentage that was the last reported QE percentage from their last submission. And so there was robust discussion at the GES committee about that topic and the potential impact that it could have on other grantees in the counties where this organization is applying, if, for example, if there were any inaccuracies in the reporting of qualified versus non-qualified expenditures. Ultimately, the team, the commissioners at the ERC had supported a finding that the organization had demonstrated primary purpose, and the committee had concurred with that during its meeting. As a practical matter, as I mentioned, we haven't sought more information from the organization. And in response to questions about whether that would be possible to do at this juncture, it would be quite difficult to seek more information from UFWF at this point if there were lingering concerns about their calculations, because the commission is making a determination on eligibility today. Our staff is going to run, our fiscal staff will run the funding formula starting next week, and it takes quite some time to run it and double check it for accuracy. And then we need to release budgets in about 2 weeks. And so it would be quite difficult, if not impossible, to obtain more information from the organization, potentially need to recalculate expenditures and run the funding formula in that amount of time. So we did want to address that because there had been some lingering questions about whether it would be possible to seek more information from the organization. But I would invite members of the committee or those who participated in the ERC or other staff who participated in the ERC to add any additional thoughts about this eligibility review conference.
So this is Jason Galkin, chair of DES. I think there's a few things to highlight. Number one is on the qualified expenditures piece. So both the determination of eligibility and the percentage are relevant for the impact on kind of how the formula works. So I think it's important for the commissioner to be mindful of that, especially our more folks. So both of those have impact. I also want to highlight, and this was kind of part of the thought process, I think, at the committee level, is that the ERCs, even with significant amount of TA, and I want to highlight the work of staff doing the TA to begin with, not just for this ERC, but generally. Despite that TA, I mean, ERCs are not audits, nor are they monitoring visits. So the degree of validation that one can reasonably expect from an ERC is not necessarily the same as one can expect from a monitoring visit post-grant issuance. And as I kind of hinted at earlier, this is one of the areas where, Dwan and I have had some discussions about, from a committee level, from a commission level, acknowledging the impact that this can have, and some of the feedback we've gotten from the community and otherwise, and level of confidence. There's a discussion about what is the appropriate amount of detail and appropriate amount of validation that gives us the appropriate level of confidence to issue that first grant, right? Like to bring someone into the fold, especially considering in IOLTA and EAF, it's zero sum. So new entry into it, especially if it's significant, has a corresponding impact on all of the other existing grantees and adjusting the formulaic, right? So, it is obviously, and Juan and I talked about this, obviously a balancing act question, right? Because, I think there's a limited amount of staff resources, a limited amount of work that we can do to audit, validate, and whatever for an applicant. And I think on the flip side, we have some situations where, they meet some of the criteria early on based on their application, and there's even less validation that goes in than what was done for this applicant, because they've met the initial criteria and you kind of pass through, more thorough analysis. So I think that is something to be mindful of as there's consideration for, this ERC and the outcome. Ultimately, I think the committee felt like, based on the ERC team's feedback and the verbal discussion they had with the applicant, that there was a reasonable degree of comfort that they were qualified, and that the qualified expenditures was a reasonable number given their articulated understanding of what was appropriate or not, right? So I think, to Erica's point, what I heard, and I think what other committee members heard, was it sounds like they understood how this is supposed to work. And I think Erica made the point, and at GS committee, I think it was Dwan, I think that the question is, we haven't validated whether their articulated understanding was applied accurately to the actual numbers, because that would require a validation effort, much more akin to a monitoring visit or an audit, and we have not done that. I think to Erica's point about additional documentation, theoretically, if we had more documentation, we could look to see, as an example, a validation of that to see whether their application fell in line with their articulated understanding. As Erica said, I think we're a little bit late in the game to be conducting that level of review. So it might be that the outcome, and this was again discussion at the GES committee, we talked about this particular one for about an hour and a half. That's why it's getting so much time right now. Maybe this is a lesson learned for how we approach the IOLTA and EAF applicants in the future, and like I said, figuring out what is the appropriate amount of validation or documentation. In a similar situation, would we defer the ERC so that there's more documentation to review prior to discussion? Those are open questions, but I think they were open questions that at GES we didn't feel comfortable holding back because of this ERC. It's like, if their lessons learned, they maybe should rightfully apply from this point forward as opposed to that.
Well, Jason, you sort of anticipated my two questions that I had. One is, do we have a history of approving applicants that are below the 75% threshold? Has that been done in the past?
I'll defer to staff, but I'm seeing nodding heads, so.
Yes, yes.
We have, but as you saw earlier in the presentation, it doesn't happen often. And this is one of the reasons originally, like this organization was recommended for an eligibility review conference, because the original application was at 25%. So certainly that fell far below 50%. And then there were, as Erica recounted, significant revisions that brought it up above 50%, then below 50%, and then ultimately above 50%. But as you saw from what Angela's presentation, it happens, it's rare though. The vast majority of programs that you approve are well above that 75%. There was Family Violence Law Center that we highlighted for you because it has a history of hovering around 50-something%. And then the Pangea Legal Services, that's a new applicant, that's at 74+%. So yes, you do, but again, it's not the common.
Okay, so my second question is there the opportunity to review? So you talked about, Jason, about how there was a clear understanding by the organization as to what they were supposed to do, but there was no testing of the data to see if the data they submitted in fact comported with that very clear articulation of what they were supposed to do. Given that they're below the 75%, is there any opportunity to come in more readily than one would normally do with respect to monitoring visits and say, do a monitoring visit after 1 year to see if in fact the data is supported by that articulation that they gave of what they're supposed to do, rather than what would be a normal monitoring visit, which might not be for another, say, 3 years or even longer period of time. Is that possible?
Yeah, so we discussed at GES like timing of a monitoring visit. I think there was concern not about what you've just articulated about like, let's make sure there's a monitoring visit kind of earlier on in the life cycle of the grant. I think there was a little bit more concern and going back and forth about the recommendation from GES to commission, because even if that were true and you put them through monitoring visit in year 1, right, the grant has already been issued and there's already impact. If what was revealed is that like, oh, actually they did not understand as we thought they did. The cat's already out of the bag, as metaphor would have it. But I think that kind of speaks to the balancing act. Like, based on what we understand, based on what they've articulated, based on the ERC team's conversation, based on what we have seen, do we have all of the indicators that make us sufficiently comfortable, given what the pattern and practice of ERCs has been, that we approve them at this stage to, as you say, okay, issue year 1 and we'll do a monitoring visit and we'll find out. And if the determination is that after the monitoring visit, maybe it's more TA, maybe it's more review, or maybe it's next year there's no funding because we've determined they're no longer eligible. And there have been instances where an organization was eligible and subsequently, for whatever reason, is no longer eligible. So I think that is a possibility, to answer your question.
Thanks.
I'd clarify one thing about the monitoring visit. So for every new grantee, we do conduct a monitoring visit on year 1. So we do not wait for, they're on a 3-year cycle, but that cycle, the year 1, they get a monitoring visit. One of the internal discussions that we've been having is usually we wait until about Q3 to do that monitoring visit of the following year. Perhaps we should be doing it in Q1 or Q2. And the reason why we wait for Q3 is because we are able to then test our application of when they spend our funding, are they doing fund accounting for our work? However, again, it's a balancing act. If we go out earlier, we may be able to catch a little bit about the application of our services. We can screen to see if their income requirements are, in their CMS system. We could do a little bit more of that eligibility kind of screening. If we wait to Q3, we're able to catch a little bit more of the internal controls. So again, a little bit of a balancing act and what you all want to prioritize and what you all want to direct us to do. But it is a year, it is a year one, so it's not that far off.
So these are kind of follow-up because Ken was asking some questions I was interested in. So and maybe I just misunderstood what Ken said, the first question. I thought he was asking about new grantees and have there been other new grantees that have been approved below 75%. And I heard the answer being sort of on other current grantees that are below 75%, where we sort of have this track record with them. So I'm curious about new grantees in their initial application year, whether we've approved them at below 75%.
Erica might have a better.
Yes. Yeah.
Yeah. Go ahead.
Yeah. There have been. I can think of in the past 3 or 4 years at least 2 applicants that were below 75% that went through eligibility review conferences like UFWF and then were ultimately found eligible. I think both those applicants that were approved were either in the high 50s or low 60s at the time of their application. You would presume that their percentage will go up upon receiving state bar funding because state bar expenditures would be qualifying. So,
okay, thanks for that. And then I guess I'll just say that I am supportive of something that would do a review so that the results of the review were known prior to the next year's application cycles, so that you would have the results of that review around their expenditure. So I don't really have an opinion about what quarter that should happen in. I just think because of the questions that were asked and the variety of information you received, it just makes sense to make sure that that's been done in time and can be reported to the grants eligibility committee so that they can look at that and ideally look at it with and without state bar funding, right? Because as Dawn said, the state bar funding, that's eligible money. So that's going to, I think, bring it up. But it's sort of what was happening before, which is the test of the numbers for the prior year. So anyway, that's just my suggestion.
Are you suggesting a monitoring visit in year one just earlier on? Or are you suggesting a monitoring visit this year before we release grant?
No. I appreciate how it isn't actually possible in the next 2 weeks to do anything that's not going to make people's head on fire. So I'm saying in next year, a monitoring visit that is done sufficiently early on the timing that the staff thinks is right, that's going to yield the information for the grant eligibility committee to sort of know that the data would for this last year, right, would just kind of test what you believe they understood is actually in fact true. That's what I'm saying, next year, but early enough so that the results are known. That makes sense, Dawn?
Yes, thank you.
This is Bob Stalker, and I take some responsibility for the lingering questions that were mentioned before. As I was on the eligibility review team and a member of the committee that approved this. And after the committee meetings, reflecting on what was said, reflecting on my rather imperfect understanding of how funds are distributed, as well as the information that we got, I talked with Jason to see if there was a way that we could get more information and slow this thing down, because I became less and less comfortable. I was a pretty enthusiastic supporter of them because they had a great staff, and I think highly of the work, the legal work that they are doing. But the numbers were, as people said, all over the place. And when you look at the staff size compared with the legal staff size, I question my own judgment on whether it was an appropriate organization. Clearly, we can't get enough information to figure that out. But I'm not particularly comfortable because of one of the things that you mentioned, its impact on other organizations. I'm not entirely comfortable with giving them money and then having a review to see if they really were eligible after we gave them. The timing is impossible, and I apologize for that, but it is a concern of mine, and an ongoing concern. And I'm not sure, as I said, the technical assistance, the staff put an amazing amount of time into this, but having more technical assistance and monitoring reviews at this stage of the process, to me, is not a totally satisfactory way to deal with it.
So can everybody hear me? Oh, I'm sorry, Aaron has a question. I'll wait until after Aaron.
I was just wondering, I'm sorry, you want to go ahead?
Sorry,
Okay.
we can't see the hands raised. So Jacqueline's got a comment, and then we'll go. If there's hands raised, we'll go to the folks who've got them.
I was just wondering, is this organization brand new? Have they been around a long time? And also, are they national or just state? And approximately, how much did they apply for?
So, Dwan, you want to answer that, or I mean, I can try to. My understanding. So,
Erica can supplement. They're brand new. They're a brand new applicant to us. They've been around, and Erica maybe you can look it up. I want to say about 20 years or 15 years. So not completely brand new. They've been in existence. Their body of legal services work is going. One of the I guess so you all know, one of the things that for us, when we look at an application that we look a little bit closer to is out-of-state work. So they are an organization that seems to do the vast majority of their work in California, but they do have work outside of California, and I believe in 3 or 4 other states. When that happens, that does trigger for us more questions. I don't know if they would say they're a national organization. I think they are presenting themselves as California-based. Primary purpose is California, and that's why they are trying to qualify for our funding. Because if they were really, truly a national and their focus was not California, they would not be eligible for these services. And then your other question about what the amount of money that they applied for. So this particular grant funding is unique in that it's not a competitive grant funding, right? So if they meet a statutory requirement, and for legal aid organizations, for QSPs, they have to be, their majority of their work has to be to provide free civil legal services for Californians. Then how we make that award determination is we look at the amount of money that they spent in the previous year, and they get a share of that pro rata. They apply per county, and they're applying in, I think, for 3 or 4 counties. And then they get a share of that county's allocation on a pro rata basis. So every county is eligible for an amount based on the amount of people in that county that are indigent. And then they share that allocation on a pro rata basis. One of the concerns for this organization is they are a very large organization. I believe they are about $15 million, and their qualified expenditures are around $8 million. So they would be getting a large award. We have ran the allocation, so I have the figure, a tentative figure of what it is, and it is a large award. And so that's why there were some concerns there that, again, with a zero-sum game, if they get it, somebody else is going to get a little bit less. I will share, though, because this is something we have wrestled with in our office, because as you've heard mentioned several times, the amount of TA that was given to this program was astronomical. And there's a couple of reasons why. This is a program that reached out just right before the application was due to seek additional assistance from us. Usually with the new grantees, they're in communication with us several months in advance, sometimes several years, in order to get into shape to apply for our funding. They reached out only right before the application. And so that level of TA that we usually provide for programs outside of the application period got squished. It got squished. Usually it's several months of TA in the period of about 6 weeks. And then you saw that there was a audit extension request to the end of it's for another month. And so that really cut down our review time. So it was been very difficult for staff because this is a very large organization, as Erica mentioned, a staff of over 60, several offices, new to our understanding of it. So we had to do this really intense review in the matter of several weeks with significant kind of revisions. But I will share with you this because I think it might be informative for you. Usually we come to you with a one staff recommendation because we feel like that's easier for you to digest. We don't have a vote in this. This is just our recommendation. For this one, I share this because this might be informative. The staff was split on whether we should receive more information, the level of degree. I think we did land on before the ERC that we all would have felt the staff review team would have felt a little bit more comfortable receiving a little bit more so we could test and do that validation. Post the committee, that discussion last week, I myself looked at the application very thoroughly. I had the staff members that participated in the ERC go back and recreate the notes. I asked 3 senior staff to review them, including Erica Carroll, who you know has done application review and led this process for many years. And I will say that all of our senior staff, with the exception of myself, so I'm going to put myself aside, have a great confidence that that number that was given was, even if there might be, you know, it's not a perfect system, even if there might be some revisions, it might knock them down a couple of percentage, maybe it might even knock them up a couple of percentages, but have a fairly, I would say more confident view of the percentages. I don't fall into that bucket, so that's why I'll put myself out there. And the reason I don't, it's not because of anything that they have presented in their materials. I've heard really excellent things that were very professional, have been forthcoming in the process. Every time we've asked them for additional information, they have had. When I looked at that kind of the record, I had not seen an instance of an application of that wasn't obvious. So obviously, they do DACA clinics, they know your rights. And to me, that's squarely very legal services. What I didn't see that I would have liked to see a little bit more was if we dissected a little bit more one of their program areas or all of their program areas to see kind of the gray parts of it, where perhaps their community organizers are doing work that they are claiming as legal services. Are they counting that or not that counting that? And giving some examples of the types of know your rights presentations or the types of cases, that level of granularity, and this I speak for myself, not my entire staff, would have given me that comfort to come to you to say that we as a staff team have confidence in that. And I share that because this is a very difficult one, because now that we're at this juncture, that's why the staff recommendation there wasn't completely the clearest. However, I will say at this juncture, it is extremely difficult for us to now get additional information because our staff is literally on hold after this meeting to rerun the validation. They've been, I think there's a staff of 6 that's been working hard the last 2 weeks to run test allocation to now do an investigatory. I think that should have been at the ERC, and I did make an impassioned plea actually at the committee to do at that junction. I thought that could have been appropriate. I do feel now at the commission, because if we go now and seek out information and say they come back and they're maybe a couple percentages below or maybe a couple percentages above, we then have an obligation because we get audited. If you know, you can't unknow, right? So we would have to go back, rerun the allocation and and that would change for everybody. And there's times where that happens, but it's like after the grant period has ended. And then for our auditors, that's okay. Like we didn't know. So now we got to make a correction. Then we call that money back and we bring it to you. But to happen now before grant agreements are released would require us to like redo the whole process. And so that I think that's the difficulty. And that's why I had actually stressed with the committee at that time, please allow us to get more information. But I respect the process. I respect the ER team's decision and the committee's decision. And so I think this is where we're at. And my recommendation would be like to take this as a learning experience and for us to improve our processes in the future.
So, thank you for that, Dawn. I think that it sounds reassuring to me that you've been very diligent with all of the efforts that you all have made so far. And, you know, being that this area, farm work and food is such an important, critical part of our socioeconomic structure, I think it's very important. And I really appreciate that you put this much effort into this because, I mean, these days, farm workers farm work seems to be a priority, and it should be.
And Aaron? I don't know.
Thank you. And I want to appreciate Dwan's explanation of where we're at. And I think you pretty much, Dwan, answered my question, but let me just see if I understood you correctly. My question is to get a more detailed understanding of the additional information that at least some staff, and I'm hearing ERC, at least one ERC member wishes that we had, and what that actually is. I heard you say it's at least for yourself on the programmatic side, and not on the financial side. So I was just trying to understand, like, is there an audit report that already exists that we can just look at? Is it financial information that would help us validate numbers, or is it programmatic? So you spoke for yourself, Dwan. I don't know if anyone else wants to say, is there like, what is the additional information specifically that would give you, a higher degree of confidence?
It's programmatic. They're a very large, sophisticated organization. I haven't spoken to them myself, but I believe that everybody that has met with them and spoken to them on the phone or Zoom or at the ERC has had a lot of, was impressed by them. We don't have any concerns with internal controls. Their audit numbers match their, corporate expenditures. The concern here is they have a lot of staff on hand. They're community organizers that they have said to us do legal services work, right? We have a really specific definition of legal services, right? That it has to be really the application of law done by the supervision of an attorney. What my understanding from the commissioners and the staff that interacted with them is that they have a high sophistication, a high level of understanding of our rules. Where I would like a little bit more just confirmation is that understanding of our rules matches the application of it in their deduction. So if we had received more information, what it would have looked like is I would have directed the staff to have them say, I think they have about 6 issue areas. Break out those 6 issue areas. For instance, one of them is climate change. Show us how many staff were in that climate change, how many of them were attorneys, how many of them community organizers. What is kind of the level of work that they were doing them? Is it mostly kind of trainings? If there are trainings, can you give us a list of the trainings? And if it's, say, 10 trainings, are you trying to qualify all of them? Or are you trying to qualify only 3 of them? I think it's informative to get that level of detail so that we can make a determination if they're applying our rules correctly. And it really is the definition of civil legal services, I think, is what's in question now. Because they have a model of community organizing, and I think from what I understand, it's a very effective model. I don't think anybody's contesting the impact, the great work that they do. That's a really important community. I think it's the inquiry is more narrow, and that are they applying our definition of civil legal services in their deduction properly? When they talk about their understanding of our definition, it seems to be there. I would just like a little bit more just to know that application happened. If that helps, Erin.
Very much. Thank you so much, Dwan.
So, if I might, first of all, thanks. First of all, staff has been amazing. Not only did they provide extensive technical assistance to this organization under a very compressed time frame, but it's, as Dwan has pointed out, it's a large organization with many different kinds of ways it interacts with its communities in many different languages across many different platforms, in person and remotely. So it's not a simple matter to put your arms around, and the staff has been valiant doing all of that in a very short time, and I appreciate it. It gives me confidence. So I think where we're at right now, and I was probably the blabbiest person in the ERC, just sorry, but it's sad but true. But I started out, I mean, besides all the work they'd done before, staff also prepared Bob and me. We had a pre-meeting where they said, okay, these are the questions, and these are the things we've got doubts about, and you're the commission member, you asked the questions. We said, yes, ma'am. So we asked the questions, and I don't think I asked them like verbatim, but at the end I said, okay, I think I've asked all the questions. I kind of, you're on Zoom, you don't know who sees you, but I'm looking around going, have we covered it? And that seemed to have covered it. And I know that I was really impressed. This is an organization that's been around since, I think, 2006. I think I told Bob decades, so it's not quite 2 decades. But so, and not only have they been around, but they are also a grant-funded organization to a large degree. And I think one of really the issue today that we've got to figure out is how much risk is involved in saying yes to them. And my perception is the risk is very small. Are they going to serve people who cannot be served? Yes, they are. Are the people they're going to serve particularly desperate right now? Yes, they are. And so kind of where I'm coming from is if they're going to do the work, and especially if it's work that LSC funded, the Fresno office of CCLS, they cannot do this work. GBLS in Bakersfield cannot do this work because it is on behalf of immigrants. So I think it's the benefits to the client communities about whom we're concerned are very high, are likely very high based on what we already know about this organization. The risk that, oh my God, we gave them a bunch of money and they went to Tahiti with it, or they used it for, I don't know, something they're not supposed to use it for, is very low. The other thing they mentioned to us, I mean, they're at almost 60%, 59 point something, I can't remember. And they, in the meeting, they were either already had received or were in the application process for additional grants to provide legal services. So in terms of are they likely to get to 75%, I think the likelihood is high. So I think the risk is low, the benefits are high. I have heard a couple of people say, yes, but it's a zero-sum game. That needs to not be a consideration, unfortunately. I can imagine, I mean, certainly for staff, they're going to have to grapple with that if the commission approves this application. And that's not trivial, but it's also not determinative. And it shouldn't be determinative. So the question really is, are they going to do the work that this money is supposed to fund? And I have not heard, and I do not see that they haven't or won't. I just want to say, Erica mentioned some, like there's somebody was complaining about them or something like that. I want to say, I never heard that until right now. And if those are serious concerns, that for sure should have been surfaced early in the process and definitely to the ERC, and it was not. So I'm just assuming that's not a real thing, or it's not a real enough thing, and I would object to our considering it at this point, and really, like in future, if there's something like that floating around, like let us know early on, because that's a reputation besmirching kind of allegation, and it troubles me that it would get made right now. So I'm going to make the motion to approve this. I don't know if they're all lumped together, but I definitely will support approval of this application.
We have some more comments here.
Well, let me say, I mean, a lot of information to absorb. Let me thank both the staff and the committee for that, thorough deliberation. If I can just kind of simplify it in my own mind, we have a longstanding organization that's doing great work to serve people. Irrespective of that, they applied within a short time frame before the deadline, and that gave staff a short period of time to do the level of evaluation that they could have done if they'd had more time. Given that, it sounds their numbers were low, and it sounds like, if just my understanding, that the option of, it's almost as if they're getting a conditional appointment because there's so many questions that were there's opportunity there, but there's a lot of unanswered questions. And under different circumstances, you could say this is conditional pending information X, Y, and Z, or another review or so forth. But since that doesn't exist, it's either they're approved or they're not, correct?
Given the stage at which we are at now.
Current procedure. Okay. So then that's the case. The question becomes,
Sorry, can I clarify that? You know, I did seek advice from OGC on whether you could say conditionally approved. So the answer is yes. I would really not do that though. I don't want, like, if this is a program we're going to welcome into the community and find eligible, ultimately, do want to stress, they have been really receptive to all of our questions. They have done nothing wrong. I would not want to put that. I think honestly, this is my take. These are procedural questions that we're surfacing. If there is desire to say not approve audit extensions for new grantees, I think we should change those rules and how we vet. I would strongly discourage you from, though you could conditionally approve them, because I don't think that's fair to the grantee. I think it's very late right now to be able to do that. I think at the moment where we could have sought more information within our right without singling them out was at the ERC. And again, I did surface every single one of these issues, and I made an impassioned plea to the committee to give us, let us seek out more information, because I thought before the commission meeting, that's like, you know, par for the course. We have a responsibility to look into everything if we yet don't feel, but the committee felt very comfortable. They voted unanimously. So I think now doing a conditional approval, it's not something that we have ever done before. And I just think it draws a lot of attention, and that's difficult, I think, for a new grantee coming into the IOLTA community.
Yeah, the reason why I brought up is that based upon discussion, that's what it appears to. It may not be the operational definition, but that's in essence what it sounds like, with the exception of the amount of money that there would be allotted, which is $8 million, is fixed.
Oh, no, they're not allotted $8 million. Let me just qualify that. The amount of money that they're claiming as qualified expenditures, and that's what the basis to determine their award is, $8 million. The amount of award that they're going to get is about 3.5, 3.7. I haven't validated that number, but it's a large award.
It's far less.
$8 million. It's in the range of 3.5, 3.7 million.
Okay. Because the point is, any organization applying to a new program, there's going to be a range of contingencies. You know, they may not have, like with grantees, they may have the full complement of staff to do a thorough review. They do the best they can given the amount of time that they have. When they know better, they do better. So you can expect the learning curve. I guess from the discussions, I was wondering if the concern was the allocation of money that they would be receiving, that grew pause, or was it just the fact that there was limited information within the short period of time?
I was just going to.
Catherine, and then we'll do Erica Connolly.
Okay, yeah, I just have one question about the motion, and you can tell me whether or not we need. I had recommended that we make sure we do this eligibility review conference within enough time so that there can be sort of a full report to the grants eligibility committee. So I don't know whether that needs to be part of the motion or if it's just okay if it's a common understanding, but I just didn't want that thread to be lost. And I had a lot of questions when I came in here about sort of what was the right approach, because it just seemed like there were so many questions that had been raised. But I honestly don't see a basis to say, because we're going to rely on the work the committee did. I wasn't there, Patience was there, others were there, so we rely on that work. And I think the best we can do, from my perspective, is think more broadly about how we can make this a better process for new grantees at in subsequent years, and make sure that we put some things in place given the questions for this grantee about doing this review. So that's kind of where I've ended up. I think a really actually good discussion among the commission members with lots of good questions. So.
Absolutely. Yeah. Thank you, Catherine. Erica, why don't you go ahead?
I know Selena actually had her hand up before me, so if she wants to make her comment first, she's welcome to.
Thank you. I can try to be brief. I think that one thing that's really important here is that this is a new grantee that is, you know, lower than 75%. And I think a lot of the conversations I heard was just a concern that they may need more support in the first quarter. And so maybe that's when the monitoring visit could happen to ensure that, you know, now we know it's quite a large award, that they're able to effectively use that for all legal services. I think it'd be very destabilizing for an organization to get a large award, think they have clarity on what it can be used for, and then later on figure out that they were not clear. Some organizations have had to give money back to the bar in the past. That has been harder. Like once the funds have been spent, it's much harder to spend that back. So I think that might help the organization, is giving additional support in the first quarter as a new grantee. We've also had several very large organizations come into the IOLTA community recently. It's always been a zero-sum game. I think the question here is just when it's less than 75%, making sure that, you know, if there is funding that's county funding that would have gone to another organization that will go to a new organization, that they're definitely using it for legal services.
Thank you, Selena. And I apologize. I can't see you on the screen that I've got. So is there anybody else that had their hand raised as well?
There's nobody in San Francisco. Nobody has their hand raised in San Francisco.
Okay, Erica, go ahead.
Okay, thank you. So I think in some ways, I'm just repeating, I think, something that Catherine already said, which is basically, I think at this point, what we do not have is an indication that they're not at 59% or whatever the number is. And I think at this point, the burden is kind of on us to show that that wouldn't qualify if we're going to reject or find them ineligible. I think I agree with Dwan and I agree with Catherine that like this has raised some really interesting questions. And I think we're in the process of doing some restructuring, and, you know, we, as our rules committee has like done a lot of work on, we've relied on a lot of norms without necessarily having a lot of rules. And I think this is a place where there may be some different rules that we need to put in place for new applicants, and, you know, for how we should, you know, what information we require when we do not know them very well, and that kind of stuff. But at this point, I understand everything that Dawn has said about sort of discomfort earlier, but we have nothing now that says they have not do not meet our criteria. And I just don't think it's appropriate at this stage to hold them ineligible when we don't actually have something that says they are ineligible. And I agree with not doing an approval conditions at this point. I like Selena's idea about a first quarter monitoring visit, just to help with some clarity and make sure everybody's kind of on the same page. So those are my 2 cents. And it looks like, yeah, Angie might has her hand up after me, and I know you kind of keep moving forward. So
Angie, go ahead.
I just, something that Patricia said earlier has stuck with me. They've been around a while and they get grant money from other sources. It shows they can comply with rules. And I would think that they will in fact meet our expectation. And we're trying to be positive about helping people. It would appear that they will, I would have confidence in giving them the money that they'll come through. Put it that way.
Sounds like a second.
Yeah, Is
Can
so.
I add one thing? I mean,
Sure, go ahead, Patience.
okay, thanks. I really, I agree with Dwan. This is definitely a learning opportunity. We never want to have to do this again, right? But one thing that occurs to me is that, especially with organizations that have significant prior grant experience with other funders, it seems like there ought to be a way to make it unnecessary to start from scratch every time we encounter an organization that's new to us, but that is an experienced grant applicant and grant complier, presumably because they keep getting grant funding. So I just wonder, and this dovetails with another interest of mine, and that is that we streamline that grant application process really so that we are borrowing and learning from other funders. And so that we could do that in a number of ways, where there's a kind of standard chunk of the grant application that all funders agree. This establishes who you are and what you're doing. I don't know, but it does seem like we could go to other grantors when we encounter somebody like this and say, can you tell us about your experience with this person or this organization? And it would save everybody a whole lot of time, potentially, I think.
Can I make a comment? Because I don't think we shared this probably in detail in our committee report outs, but at the executive committee, we kind of talked about kind of maybe structural changes. And so we are going to be forming a staff-led working group of a couple commissioners, and we're going to bring before you, hopefully in November, some recommendations. Some of them will hopefully not require a rule change. Some of them might require a rule change. So we'll engage with Erica and Catherine on the rules committee and perhaps even statutory changes. So we are thinking about these things. We're thinking about whether whether to move up the application timeline, perhaps for new grantees, whether there could be potentially a renewal applications for existing grantees. At the application, we don't actually go into too much depth on internal controls. So that might be a way, like if they already have an audit and we have to kind of figure out who those kind of reputable organization funders are, that maybe can replace the internal control section of our application. But I will say, though, the application is really technical and specific to us. So I don't know, though we will strive to shave out off we ran or maybe build out parts that are necessary. We're not going to be able to revamp like it completely. Right. But we will bring to you a recommendation in November.
Thank you, Dawn. So we've got one more comment from Vanetta here. And then I think we should move to, then I'll make a quick comment, and then if we have a motion, I think Patience had made the motion. We'll look for a second, have a vote, and then we'll take a break because we've been going for a little while now. So I'm going to give it to Vanetta.
Okay, thank you. Just a couple more points. This is a 3-year grant, yes?
No, it's 1 year. 1 year. They apply.
Oh, it's only
1 year, yes. The 3 years is in reference to monitoring visits. So assuming they stay on in a grantee, where our monitoring cycles every 3 years, unless you have issues that we might go out for repeat that year or the following year. But it begins on year 1. So every new organization will get monitored next year. For this particular organization, I have already made a note that it will happen in Q1 and even perhaps January or February. I don't think you need a motion for that, Catherine, but we will not forget. It's already on our list. And perhaps all the new grantees, not just them, so that we're to not single them out.
So in essence, it's talking about risk reward. It's a 1-year opportunity to give an organization funds for a good cause and see how they perform. And if they meet the requirements within that 1 year period of time, that kind of affirms the benefit of giving them this being flexible, right?
Yes, I think for this particular grantee, that's what I would recommend. But I do think we need a revamping of it, because the truth of the matter, and this is why I respectfully disagree with Patience and like the zero sum analysis, because we do need to take a look at like how we review applications, because the truth of the matter, an organization is getting $3.7 million. There are going to be mass layoffs from our other organizations. That is reality. And I say that not lightly, because it's not going to be a few layoffs. It's going to be mass layoffs. So again, at this juncture, I think it's too late, but we have to think about that as we are increasingly getting new grantees and there are more state funding distributed for legal services through other entities, it is going to impact us. So I think we need to think about that for the future of the IOLTA program.
Okay, then one final point. I remember from being on other, other committees where I think it was the fellowship, the scholarship committee, where a lot of organizations applied, but some realized or were counseled that their application, that it might be best for them to defer applying until the following year so that their application would be stronger. Has that consideration come up for this organization, or is it position that the limitations would warrant that, or do you think they're functioning high enough to be able to move forward?
I can jump in on that. Compared to discretionary grants, these are grants where you're statutorily eligible for them. And so when staff provides guidance, as we did with this organization, when they contacted us, we gave them the best information we had based on, what was stated to us before we received their application. And in particular, things like their audit requirement, we explained the process of when we knew that they wouldn't be ready at the time of application to produce an audit, that they would need to seek an extension and what that process looked like. But staff doesn't give, we're not directive with them, for example, to say you shouldn't apply this year, you should come back next year under those circumstances, that we leave that up to the organization, as we did in this instance, to make their own decision about their ability to get what they needed together in time and to apply. I don't want to put words in their mouth, but the impression I got was that they thought they would give it a shot and see what, do their best job that they could with the time and information that they had. And, to some of the discussion that's been happening around this, that, if we had been able to get some of that beforehand, we could have done some of this preliminary work in guiding them and giving them better orientation to the requirements of the grant and this very specific information we seek beforehand. So we did give them information on the requirements and what it would take to, for example, get an audit extension, but we don't counsel them as to, wait until the next year, for example. That's really their prerogative.
Yeah, but I mean, related to that though, we've had internal discussions on really when we should cut off the valve of the technical assistance, because with this organizations, we gave them technical assistance, I think up until the day before, the 2 days before, and that's why the revised application, the 2 members got it very late, and we apologize for that. So I think there does to be kind of a rethinking about when an application comes through, what is appropriate level of technical assistance, and when is it just we have to say sorry and we're closing the door to that and make a determination. It was I think it was unfair for our staff and our commissioners in the cycle.
Yeah, and I think this goes to what you've been discussing about coming up with potential rules or policies around this for first-time applicants that, staff currently is not in a position to tell an organization, that perhaps they shouldn't apply. But if there are other guidelines around, as you said, whether there's cutoff or a certain amount of threshold information they need to produce before they would be allowed to move on to the full application, that sort of thing would be helpful to staff, but that's not something that we currently feel in a position to tell or to make those cutoff decisions.
Thank you.
All right, thank you, everybody. Thank you, everybody, for this robust discussion. I think this is really valuable for us as a commission to be grappling with these issues. This raises a lot of process questions, timing questions, but also substantive questions. And I think I'll just make a quick point on the zero-sum concept, because yes, the landscape is something that's obviously something that we all have a view on and want to be concerned about. I also want to point out, we also have an obligation. We have a fiduciary obligation with respect to these funds from the legislature and with respect to the statutory nature of these. So, it is important for us to make sure that we're vetting correctly, we're getting the right information, we're doing the things that we need to do in order to satisfy those obligations. So I do agree that given where we are, given what we know, and, you know, that in my view, the right thing to do is for us to move forward with this. But it's also given us a lot to sort of help reinforce and strengthen our procedures going forward. And with that, I think, Patience, I'll give you the opportunity, or if anybody else wants to jump into the motion. I think Patience started making the motion.
At this point, we have reviewed 2 of the ERC results. The Dependency Legal Services and United Farm Workers Foundation. And I move that the commission accept the recommendations of the GES committee with respect to each of those applicants.
Give a second.
I'll second that.
Angie seconds. Let's have a roll call vote.
Alicante,
Yes.
Babcock,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Galkin,
Yes.
Gonzalez,
Yes.
Huang, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sanville,
Yes.
Smith,
Yes, as to DLC, abstain as to UFWF.
Stalker,
Abstain as to Dependency Legal Services and no as to United Farm Worker.
I'm sorry, did you say no or? Okay, thank you. Escobedo, Milrod,
Yes.
Alsaroff,
Yes.
and Connolly.
Yeah.
That's 13 yeses, 1 no, 2 abstentions. Motion passes.
Thank you, everyone. Let's take a break, bio break for, let's say we'll come back at 2:35.
I'm gonna mute us if you all are comfortable with that. Okay.
It's 2:35, so if LA and everybody on Zoom is ready, then we'll reconvene. Amin, if you're ready.
Amin stepped out, but
Okay.
he's here just
Just
a
let me know when
moment.
he's back then.
Okay. You're on.
Maybe I overlooked it. It's possible.
All right.
Yeah, we're
We're unmuted. We're ready to go.
We're
when you are.
unmuted, we're
Yep.
ready to go? Okay, Jacqueline's gonna join us in a second. Let's go ahead and get started.
Okay.
Erica?
Yes, sorry. So resuming our discussion of eligibility review conferences, the last one that we have to discuss is Yuba Sutter Legal Center for Seniors. So Yuba Sutter is a former grantee reapplying for funding in 2026. They were found ineligible for funding this year in 2025 for failure to produce an audit by the extension date they had been granted last year. And as I think Angela detailed earlier, audits are a fixed requirement for the application process that, you know, a grantee or an applicant cannot be approved without submitting a financial statement as part of the application. So audits are due May 1st every year. Staff have been able to grant an extension through May 15th, which was the audit deadline. We had sent out reminders prior to that about meeting the deadline. We received a request from Yuba Sutter for an audit extension on May 16th, which was after the application deadline, and then received an updated request on May 23rd from them seeking an extension. And I believe their executive director sort of detailed some of the reasons for that in his public comment. But the purpose of the eligibility review conference was to assess that failure to submit the reviewed financial statement from their fiscal year 2024. There were also other concerns about the organization's prior audit findings related to internal controls. So there had been repeated audit findings on their in prior years from 2021, 22, and 23 about things like their inconsistent time card documentation, not having pay rates formally documented in personnel folders, lacking documentation about total hours worked, untimely bank deposits, and then insufficient documentation to reconcile employee timesheets to their grant and contract billings. And then there was also concerns about the organization's reliance on their auditor to draft financial statements for them. So those were the concerns regarding internal controls. And then the organization also has a history of late submissions, a pattern of late submissions on its reports and applications to the state bar. So the purpose of the ERC was to address those three issues. As noted, during the ERC, they explained their challenges with finding a firm to complete their audit, and had engaged an out-of-state firm to do it, but couldn't complete it until July 26th. And so the team that participated in this ERC found them inadequately prepared to address the identified concerns, and that the organization was not demonstrating extraordinary circumstances for an extension. So just a reminder that if an organization can't meet the audit deadline, the commission can either grant an extension when an organization demonstrates extraordinary circumstances, or if there's a lack of extraordinary circumstances, can do so with conditions placed on the organization. But by the time of the ERC, as well as the GES committee meeting, we had not received the financial statement because they both took place prior to July 26th. Even though the organization hadn't demonstrated extraordinary circumstances, the recommendation had been to ultimately allow them to submit a financial statement if they could meet that deadline of July 26th with a board-approved and reviewed financial statement. I don't know if we've discussed this before, so I just want to highlight the difference that organizations need to produce an audit from an independent certified public accountant unless their gross corporate expenditures in the prior year are below $500,000, and then they can submit what's called a reviewed financial statement, which provides a slightly lower level of assurance from the auditor. It is similar in function to what an audit would do, but it's less expensive and less intensive for these smaller organizations. So Yuba Sutter actually fell below that $500,000 threshold, so that's why they were intending to submit a reviewed financial statement. So the outcome of the GES committee was to, permit them to, if they could meet the deadline that they had set for themselves of July 26th. After the GES committee, Yuba Sutter submitted a reviewed financial statement on July 26th through our platform of Smart Simple at 11:55 p.m. And then they submitted their proof of board approval at 12:23 a.m. We received a communication from them on Monday morning, July 28th, indicating that there had been an error in what they had originally submitted, and asking to resubmit the financial statement with the corrected version. And so we are in receipt of that now. They sent it subsequently. One of the issues with the reviewed financial statement is that it doesn't address prior known audit findings regarding internal controls. It doesn't speak to those. So It's our understanding from the ERC that Yuba Sutter indicated they were going to hire a CPA to help them with internal controls issues. I don't know if we know the status of whether they were able to hire somebody or the work that's been done in that regard, but we don't have anything from the financial statement that would speak to those concerns. So that is sort of an unknown quantity at this point. And then, as I mentioned, there are still lingering concerns with Yuba Sutter's pattern of lateness. This year, in 2025, they've had to submit reports for other grants that they've received from the state bar or close out for the prior year where they did receive funding. And I believe to date this year, we've received 6 reports late from them, anywhere from a few days to up to 3 weeks late. And so that is still an issue that remains unresolved. So based on sort of a global assessment of the issues, given the fact that the organization didn't demonstrate extraordinary circumstances for their audit, and then with what they submitted, we're still missing information about their prior audit findings and this ongoing pattern of lateness. The recommendation was to find the organization ineligible for 2026 funding. If the commission wishes to find them eligible, it would do so with conditions due to the lack of extraordinary circumstances. And so in that case, if the organization were found eligible, we would recommend requiring the organization to obtain a new audit to address those findings, and then to report back on how those findings have been resolved. And if they haven't been resolved, to submit an action plan to the commission to be approved by the commission for them to take appropriate and timely steps moving forward to address them. And then participating in a program and fiscal monitoring visit in 2026, as well as to require them to submit their reporting on time and without error. I would invite those who participated in the ERC or any staff who participated to, if you had any additional thoughts or comments. Yes, Angie.
Okay, I was on the ERC and my hats off to staff for how you worded the memo. It's accurate, it's precise, and it's objective. And the conference was any of those things but. So thank you for pulling that together. It's a great memo. But it's exactly right. I feel for them. They lost their funding. Then, of course, they've probably lost other funding. They've had a lot of change of staff. But it's a persistent kind of a practice. They've been late for years on one thing or another. They were not technically late this time, but just exactly right to the wire. They seem not to be able to take any kind of action until the hammer is just about to drop. And I don't know if the conditions, I think they should be preconditions before they apply again, but I'm not inclined to try to change your minds about denying them this time. I think it's a close call, but we've got to maintain our own responsibilities as well. So that's it.
Thank you, Angie. Jason? I just want to highlight something for everyone, and it was in Erica's notes here, but the thing that made them previously ineligible was the same thing that they requested repeated extensions on this time around and got it in like at literally the last second. So it's not as if they weren't on notice of the need to have audits done, because the lack of the audit being done is the thing that made them ineligible 2 years ago. So I would be much more willing to be flexible, and think about the conditions that Erica mentions here in the last bullet. If we were talking about, novel circumstances for which they they got the audit piece, but now we need to clean up this other thing and whatever. But I see it as the same issue, just remanifesting.
And while I realize it might be tough to find an auditor, I mean, there's been more than ample time to prioritize, and there's a grantee community which probably could have touched with auditors and whatever. I am very sympathetic to the region that they were providing services. It's one of the few organizations that we have grants out to that supports what I would call an extremely rural area. Relative to our other grantees, Yuba Sutter area is North Sacramento. It's pretty rural. So it's disappointing, and I have theories and speculation as to why this kind of administrative stuff may not be front of mind. But I don't think we as a commission, or I would posit that we as a commission should not be lowering the bar of our expectations simply because the size of the organization, the community it serves, geographically and otherwise, requires the same people who are working on these administrative matters are doing the day-to-day work. And I think that's their understanding of the folks, like even when they come on public comment, they're coming to public comment, talking about the grant situation, after doing all of this in-person work in the court and so on and so forth. So I sympathize, but I don't think, given our fiduciary duty, to Amin's point earlier, I don't think that we can compromise, what the expectations are, and it doesn't give me a whole lot of confidence of their administrative capacity to meet our expectations. But maybe that's something they can demonstrate in future rounds. Thanks, Kevin.
I just had a couple of comments and questions, I guess. I mean, I'm familiar with what happened before. The prior audit, I believe, could not be completed because a prior ED and the staff that was there at the time couldn't provide the documentation to justify the expenses, and nobody knew how to get it, is what I recollect happening. And so it's sort of like, how do you ever overcome like what a prior person did? Because you're not going to, the auditor wouldn't issue an audit because they couldn't find the documentation for the expenses. So it's sort of that, it's just like a complication to me. So I guess, so we said they could do a review. And then I guess, does a review have to address the required the prior audit findings or not? Because we allow a review, but I don't know how a review is different than an audit, and whether it's a requirement that the review address the prior audit findings. It is?
No, I don't believe it's a requirement. The audit would have done, if they had done an audit, it would have engaged in certain testing that a financial review does not require.
Right.
I think what we're trying to say is that there is no other way for us to, they haven't provided any other details either about how they're addressing the internal controls questions. So information is not forthcoming on that point, regardless of the vehicle for it.
Yeah, I just don't think we can tie it to, well, they got a, we allow a review, and reviews don't address prior audit findings. So it just makes me uncomfortable to say like the review wasn't adequate because it didn't address that, but it doesn't have to. And then when did we ask them to get to address the other, when did we ask them to address the prior audit findings, since we accepted? What?
Because it wasn't, you're correct that the review doesn't require that, but that was the kind of the crux, one of the two main issues in the ERC, and was asked of them, how did you address serious internal control deficiencies? And the response was unsatisfactory to the two commissioners. And so we're just saying that then another juncture would have been, but obviously, yes, it was a financial review that doesn't require it. So we were just saying there wasn't not additional information that could have bolstered or show that they had resolved those issues.
So, and we were clear that they needed to address the prior audit findings by a specific date? Like, I just try, I wasn't there. I'm a, you know, like, I believe in supporting what people decided that were there. I'm just trying to understand is all.
My understanding was that they were given three areas that we were going to look at, and one of them was the audit that never got done, and two were the internal controls, and three was being late. And so whether the review covered the previous audit findings was would not even, I mean, it wasn't requirement of, we had a separate issue on whether they had addressed the internal findings. It had nothing to do with the financial piece of it, but it was a separate issue. Did I make it clear?
I don't know that I'm entirely clear. That doesn't mean you weren't clear.
Well, I think, Catherine, what Angie's saying is that they were on notice for the purposes of the eligibility review conference, that this would be a topic that needed to be addressed. And so, you know, and the information that was, I was not at the eligibility review conference, but my understanding is the information that was shared there was that they had engaged the services of a CPA to work on those prior findings, but that perhaps that work had not started, or there were no more details about sort of the plan for how and when those things would be addressed.
It was another thing like, oh gosh, yeah, no, we're working on that. We're going to get somebody next week. You know, it just, but they hadn't actually done it. So they were, you know, when we raised the issue, they said, oh yeah, that's right, we're going to do that, but they hadn't actually done it on their own.
Yeah, I hate to paint organizations with a broad stroke, but whenever we hear situations like this from the staff and the working committees, it always seems as if there's one, you know, common denominator, which is a capacity issue. So I think that may very well be the case. And I just even pulled up their 990s, the recent ones that are posted, and they had a deficit for their fiscal year. So they haven't posted for the most recent would be as of June 30th. Now, I guess, if they have done an audit, but the ones that are posted, it shows a deficit. So the information that you're sharing now and what the working committee is discussing as well, it seems consistent with there being a capacity issue. So that seems to be the case for this organization.
I mean, they did not get funded last year, which contributed.
Well, they ran a deficit, and there's been consistent issues based upon what the with the working committee and what the staff is showing. So that there's some sort of problem somewhere. I don't know where that is, but there's something exists, and it could be the function of it being a small organization and not having the ability to do certain things and needing the resources. But that seems to be where they are.
I was on the grants committee when the first issue arose with the audit that they could never produce for the prior year. So I was honestly just trying to catch up with what was required. That's what I was trying to find out. Not really speaking to the stability of the organization, just like trying to understand.
I guess kind of to Catherine's point, my comment earlier was not necessarily that they failed to address that which there's an absence of documentation for them to ever address, right? So it's kind of like, are we, you know, whacking them over the head for something that is more or less impossible for them to fix? My concern is more of you knew that audit and the need for doing the audit was present, even if you couldn't do it retro, which got you disqualified in the first place. By nature of that whole discussion, you were on notice of the importance of getting it done in time to secure an auditor, to have that all prepped in a timely fashion. That you're not doing so, not that you weren't going backward, but you're not doing so until the last minute, for me, is indicative of, you know, an administrative shortcoming. And that's my concern is, you know, okay, like maybe they're still getting their bearings as, you know, they're taking over and what have you. And maybe that means next year they'll be prepared. That was what made me uncomfortable, was like, are we still struggling to kind of get up to speed? And this is an afterthought as opposed to a priority.
Aaron?
Yeah, one thing I'm struggling with a little bit as I listen to this good discussion is the issue of whether their financial review was timely or not. You know, coming out of the grants meeting, it sounds like the ERC and the committee approved to the within the authority the committee has at that time to give them until July 26th. Looking at this slide that's on the screen now, I actually think reasonable minds could differ as to whether they were late or not. I could argue they were on time. And so I'm a little uncomfortable giving them a message at one point in time that July 26th is acceptable, and then later saying, no, actually it was late. To me, that is kind of the tail wagging the dog. The real issue that I think as, stewards of public money should really be the focus is not whether they're 23 minutes late or not, but this internal control issue, because that really is the meat of managing public funds. And hearing what I'm hearing, again, having not been on the commission when this came up last year and having not been on the ERC, but understanding that staff and the ERC members gave them notice of a concern about those internal control issues that Erica mentioned, and hearing that the ERC felt there was an unsatisfactory explanation of those. To me, that's the point, not whether, the board approval was on time or not. I am concerned about that. Having led a very small organization before myself, I absolutely think there's a capacity issue here. And I think the reason they had a deficit is because they lost funding last year. And I listened closely to the public comment earlier, and I do really, really empathize with the difficulties that small organizations have in keeping up with all the administrative requirements. I would like to, if that executive director is still listening, personally offer technical assistance for myself as a former leader of an organization that had an even smaller budget than you currently do at one time. I had a great CPA firm that walked me through it. I can give you their name. I really sympathize, and I do believe that they can get there. But I am concerned about those internal controls. Those really do need to be in place. So that's where I'm coming from.
Thank you, Erin. Erica?
Hi, thank you guys. So first off, Erica Carroll, I'm sorry if you said this. Do we have their last monitoring? When was the last time they had a monitoring visit? And were there any particular findings from that?
I can pull that up. I'm sorry, I don't recall off the top of my head.
I guess I was more just generally, I know they had a change in leadership. My understanding is most of our concerns from the internal controls come from the prior audit. So is that sort of, and then we see this late financial review as further indication. Is that, I just want to make sure I'm understanding kind of where staff is coming from on the internal controls.
Yes.
So my recollection of the eligibility, the monitoring visit, I think I did that. And it was at the time there was a transition from the former ED to the new ED, and both of them were there, and two board members, which was, as I recollect, a bit awkward. And I think there were some findings, but I don't know that I can remember what they were.
If you give me a moment, I can pull that up if you want to keep discussing.
Yeah, I think, and I just want to make sure, is the staff recommendation that we find them ineligible because of inadequate internal controls? I just want to confirm that's it, not versus the fact that not giving them an extension on the financial review or anything like that.
Can I jump in?
Well,
can I jump in because I did consult with Raul and OGC around this. If you all decide to not want to fund them, the recommendation, and Raul can chime in, from OGC is to not approve their audit extension and not find them that they had extraordinary circumstances. That would be the cleaner way to go.
But I at least find that difficult because we allowed a review and it appears it was provided on the day that it was due. I gather maybe it was 23 minutes or something late.
Well, just a point in contact on that though, like the extensions are never like agreed to until the commission actually approves them. So everyone who's given an early, but it is a point to like make clear, right? You are dependent on the fact that the committee may approve a commission, and the commission also, that's what we did. These are early ones and had to approve them. Or we approved those audit extensions despite the fact that they were provided in. Not saying that that's, or I
don't
think
that's
a way
great.
for us to. I am not saying that we should then end them eligible that way. I'm just making like a technical point that that no audit extension is actually given until the commission approves it, which we have done for the other entities, and which we generally do. I'm not saying we have had a practice of doing it that way.
And I think part of it, Catherine, so sorry, go ahead, Erica.
I think our finding was even if they turned in the audit on time, there were still the other issues that didn't get addressed as to how they were going to resolve them, which in the memo in that last paragraph where it talks about if we're going to approve them, that the following conditions, I mean, all of those were why we just felt we couldn't approve them. So getting, and I agree, the 23 minutes or whatever is not important. I think they did get it in, but they got it in within 5 minutes of a deadline. It's always just at the very last minute. And I agree there's a capacity issue, and I agree that they do really good work. But
so I'm actually more comfortable with, sorry, go ahead. I'm sorry.
I was just going to say, maybe we're not the right organization to fund them. Maybe there are other organizations they should turn to until they get their act together and then come back.
Yeah, I guess I feel like there are many organizations that turn in things at or shortly after the deadline, and we have not made that the basis for determining somebody's not eligible. And so that's my discomfort of sort of an application of a rule in a different way. If there's seems like there are other things the eligibility and budget committee found, like they lack internal controls or a mechanism of documenting their internal controls, which to me feels more comfortable than saying we're going to deny eligibility based on a ever number of minute late application. So
we've got a few hands raised. I'm going to go.
Sorry, I can't see anybody's hand.
No, you're good. I don't want to interrupt you. Let's go. We have Erica, Raul, and then Jason.
Patience.
And me.
And Patience.
Thank you.
Okay. So the one thing I'll just say though, despite my comment earlier, I also can see a way in which we actually do give them funding, but we put significant conditions on it about improving their infrastructure and using the funds to do that. We've done that with organizations in the past where we've had severe concerns with their internal controls. And we've basically said, if you're going to take our money, you must. I mean, we did this like last year, I think, where we said, you need to hire a consultant, right? You need to have a better board, you need to have better infrastructure. And essentially, the funds we give them may just be the funds that they use to get their house in order. And so I'm not sure that that's going to like change the deficit problem that Jonathan flagged, but like that can be a useful deployment of our funds with tightly controlled conditions that require benchmarks and improvement over the time period. It's just something I know we've done in the past, and so I throw it out there as not. I fully respect staff's recommendation and totally understand the reasoning for it, but if people are uncomfortable, that is another way that we could go.
Thanks, Erica. Raul?
Hi, yes. I just want to state that, it is a fully an appropriate basis to deny them based on a lack of extraordinary circumstances. that effectively means the extension is not approved and the application is incomplete. And that alone is basis to not approve them.
You're all, Jason. Yeah, I mean, I appreciate that what Raul's comment is that it's legally sound and sufficient to do so. But to Catherine's point, I agree. I'm also not comfortable as with that being the primary basis, given that they had requested an extension. You know, GES considered, you know, we'll call it tentatively approving, you know, and making a recommendation to grant an extension to this body. And in my role as chair of GES, I'm not comfortable saying that, you know, as chair, that should be like revoked and reconsidered. Like, I won't vote against it because GES recommended that that's what we do, so I will vote in line with that. But I think there's a nuance here, which is that you provide, like, even if you were determined to have provided the audit timely, the content of that audit upon review may demonstrate that you lack insufficient internal controls. There's still another step that goes into reviewing the whole content of your application, even if you're given an extension. So, I mean, I think like Catherine, I would be more comfortable if there were, you know, they were found ineligible on that basis. But if it's the technicality of 23 minutes late, or you shouldn't have been eligible to get the extension to the 26th, I mean, I would only be comfortable with that if that were a determination and recommendation, at least for me as chair, coming from GES, that we wouldn't have wanted them to get because it didn't meet the extenuating circumstances at that stage. But we were making that, we voted on making the recommendation to say it's fine. So, thanks, Jason. We're going to go to patients, Judge Rossi, Judge Wayne Gutierrez, and then in the interest of time, I'm going to ask that if somebody wants to make a motion, that make it at that point. So patients, you want to go ahead?
Thanks. I hear the 23 minutes, it's de minimis, and at GES, we said to them, you have a deadline. And he said, well, we'll meet it, you know, we'll do our best, but we're not sure about the board the board approval. We said, dude, it's not complete unless your board approval is included. And he said, oh my gosh, well, you know, I'll do my best. And then turns out there's no board approval until, you know, that's what you're waiting on the extra 23 minutes for. And then turns out Monday, the thing is inadequate for whatever reason, they've got to correct it. So, you know, of course, you can say, well, that really, honestly, we're not gonna deny you based on that. But I think more importantly, that is evidence of capacity. And I hear Erica saying, well, we can help them, but, you know, grow their capacity. And that has a kind of appeal, especially given the people they serve and where they are. And I have it troubles me a little bit to spend this pot of money that is limited and is going to be more limited in the future, most likely, in order to essentially create capacity in an organization rather than allocate it to an organization who will serve clients tomorrow with the money. And so it seems to me this organization has shown that it's had several years over multiple executive directors, and I understand the disruption that occurs between regimes, as it were. But it makes more sense to me to say to this organization, you knew exactly what had to be done by exactly what date, time, and minute, and you failed to do it. And this is totally consistent with your history. And you just haven't shown that you can, you know, this is the major leagues. You are, you know, we're sending you back to the Bush League or whatever it is, and, you know, home, get some other funder, as Angie suggested, might be more appropriate. So I hope that, I mean, between this conversation and the one we just had, what we're beginning to see is a lot of time, energy, and money spent on technical assistance and bringing people up to speed so that they can serve clients, and there is desperate client need. So I personally would be very supportive of making our application standards more demanding and making them, and I'm not saying these are the people to do it with, because they haven't had notice, et cetera, but it's time to really turn away from our super user-friendly, whatever you need, my door is open, I can, away from that to we're giving you a lot of money and we expect you to serve clients with it, and we are not fooling around. And so be prepared to meet high standards on time or look elsewhere for funding. And so this again is another learning experience, but I mean, I guess we could give these folks money and condition it, but I mean, this would be, I mean, seriously, we cannot keep doing this.
Thank you, Patience. Judge Rossi?
Thanks. I think I just want to add my 2 cents. I mean, I don't love the idea of, I guess it's not a technicality. I mean, they were late. If it's for my courtroom or someone else's courtroom, the statute of limitations is statute of limitations. You can't meet it. You can't meet it into, I think it was Patience who was just talking point, it's a bigger problem. I don't love the idea of saying they're late, so let's just find them ineligible. But so I think we find them ineligible on other grounds. I don't love the idea of conditional funding. I think they've had a couple of years now with a lot of staff support, it sounds like. And it just hasn't happened yet. And so I don't think giving them, I think it's a fiduciary duty to not give them money at this point. So
Thank you, Judge.
that's my 2 cents.
Judge, bring your chairs up to put your hand on. So, but okay, so I'd say, does anybody else have any comments before we entertain a motion?
I don't know if there's still if people are still interested in the monitoring visit piece, but I do have that information now if you want it.
I'm curious. Do you mind just
Sure.
sharing a little bit? Thank you.
Yes. So their last monitoring visit was in July of 2024. One of the findings was that we were unable to complete the monitoring visit as scheduled. It had originally been scheduled on April 30th, but UBICETR failed to produce the financial documentation that we needed in order to conduct testing, and so their visit was delayed until July. There were some findings related to staff performance evaluations and the executive director not receiving an evaluation, and then there was a fiscal finding related to salary authorization, lack of documentation for the salary that was being paid, which I believe aligns with some of the prior audit findings as well. And there were the prior monitoring visit to that in 21 had fiscal findings as well. So.
Thanks, Erica. Raul?
I just want to raise that it could make sense to, if you decide to deny them, to do so on both the fact that they were late and the other factors that you consider them ineligible for the grant. It would serve as a separate independent basis to uphold the denial.
Well, can you just repeat the last thing? It was a separate what basis?
It's just so that there's it would be sufficient for both purposes to say that we deny for both reasons. My advice would be that would be a stronger basis to do so.
Erica, would you mind going forward to the slide with the resolution that is proposed? So it looks like the staff recommendation for the resolution includes a variety of things. Is there anybody that wants to propose a motion either based on this or with the modification?
Can I make a motion only on the, we're only doing the first resolution paragraph there, right? We're not gonna consider the attachment F resolution. So I would make a motion to strike, to approve this resolution with the language stricken due to failure to meet the audit extension requirements, as well as the language and meet reporting deadlines.
Then I'll second the motion.
So the resolution is further resolved that the Legal Services Trust Fund Commission finds Yuba Sutter Legal Center for Seniors ineligible for 2026 IOLTA/EAF funding due to failure to address internal controls concerns. Is that accurate, Erin?
Correct, thank you.
Why did you want to take off the reported deadline?
I agreed with Catherine's comment earlier that I'm not personally aware of a previous instance of using like a grant reporting deadline as a basis to make an ineligibility determination. I don't think it's the strongest reason here. And
Well,
it's
it's
not
not
necessary.
My understanding of the reporting deadlines is in general, they're consistent failure to meet reporting deadlines, not just this one audit report. Am I wrong?
Yeah, I understood that from the memo.
Can a deadline please be a deadline? If it's not a deadline, it's not serious. It's not a requirement. So I would really hate to see us remove requirements and deadlines as a basis when they haven't been met as a basis for terminating funding. That's one of the requirements. I never, as an ED, took it as anything but like, this is a drop dead date by which this must be done. And I wouldn't like to send a different message.
Can I make a suggestion? If you want to find them not eligible, can you please listen to the advice of counsel? Because Raul has thought through how this on appeal or what could be withstood in the court could make it airtight.
I listened to it, and my motion is what it is. So we can vote on it, maybe.
Yeah, if I would say, there is a motion. I think we should just move on it and like people can vote, and then you can always if someone wants to make a different motion, they can make a different motion if it doesn't pass.
So we have a motion, we have a second. Let's do a roll call vote.
Can we restate the motion?
Sure. The motion is further resolved that the Legal Services Trust Fund Commission finds Yuba Sutter Legal Center for Seniors ineligible for 2026 IOLTA/EAF funding due to failure to address internal controls concerns. Let's go ahead with the roll call.
Alakani,
So we're just voting on the wording of the resolution right now, right?
On the one that was just read.
Okay.
Not what's up there. So it's only on internal controls.
So it was approved to change it.
It was,
That's
the
the
motion was
motion.
approved to change.
Could you change it so everybody's very clear, just because it's complicated? Erica, could you physically write out what it is? Thank you.
can you make it bigger?
Motion to change and adopt has changed.
Oh,
All in one.
change and adopt.
Yeah.
Okay.
Not just change the language to then be.
If this motion fails, I will be making the complete motion.
Everybody see that?
No, but I know what it says. So.
Okay, let's go ahead. That's it.
Alakani,
I do not approve.
Babcock,
No.
Blakemore,
Yes.
Campbell,
No.
Balkin,
Abstain.
Gonzalez,
No.
Wong, King,
No.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
No.
Sandville,
Yes.
Smith,
Yes.
Stalker,
No.
Escobedo, Milrod.
Yes. I mean, no.
That was a no.
No. That was a no.
Got it. Al-Saraf
No.
and Connolly.
No.
That's 3 yeses, 10 noes, 1 abstention. Motion does not pass.
I move the original motion, or the motion as originally stated, except taking the "and it is" out of the end there.
Do we have a second?
I second that.
Jacqueline's seconded. Let's do a roll call vote.
Alakani,
Yes.
Babcock,
Yes.
Blakemore. I'm sorry,
No.
Campbell,
Yes.
Balkin,
Abstain.
Gonzalez,
Yes.
Huang, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
No.
Stalker,
Yes.
Escobedo, Milrod,
Yes.
Al-Saraf,
Yes.
and Connolly.
No.
So that's 10 yeses, 3 noes, 1 abstention. Motion carries.
Okay, thank you, everyone. Erica, do you want to
Yes.
complete presentation? Go ahead.
Yeah. So after we've gone through these eligibility review conferences, the remaining question is the eligibility determinations for the remaining applicants. And so the recommendation from staff and then from the GES committee was to find those listed in your attachment F to the memo as eligible for 2026 IOLTA EAF funding.
Catherine moves the staff recommendation as.
We have a motion from Catherine. Do we have a second?
Second.
Patience seconds. Let's do a roll call vote. We're not able to, is the roll call going? We're not able to-
Alakani,
Yes.
Babcock,
Abstain as to Public Law Center, yes as to all other applicants.
Blakemore,
Yes.
Campbell,
Yes.
Balkin,
Abstained as to Legal Aid Society San Bernardino and Riverside Legal Aid. Yes, that's all.
Gonzalez,
Yes.
Huang, King,
Yes, and abstain as to San Luis Obispo Legal Assistance Foundation.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sandville. Was that a yes?
It was. Yes, that was a
Thank
yes.
you. Smith,
Abstain as to Family Violence Appellate Project and yes as to all others.
Stalker,
Abstain as to Legal Services of Northern California, and yes as to all the others.
Escobedo, Milrod,
Abstain as to Central California Legal Services, and yes as to all the others.
Al-Saraf,
Abstain as to Legal Aid Foundation of Los Angeles, and yes to all others.
Connolly.
Yes.
That's 14 yeses, 1, 2, 3, 4, 6. Abstentions, motion carries.
Okay. Thank you, everyone. We've got a bit more time and a few more agenda items to go through. So I'm going to turn it over right away to Mara to talk about the CalHFA 2.
It's still pro bono.
Yeah,
I'm sorry, are we still?
we're still in IOLTA EAF.
Oh,
Can
I'm
you
sorry.
believe it? We have one more thing,
continue.
just one more
Sorry,
thing.
that's
No worries, no worries. But you have one more voting item actually related to IOLTA EAF, but boy, is this one fun. This is the pro bono allocation that we're going to just briefly run through. So as you know, 10% of funding in each county is set aside for QLSPs that coordinate recruitment of substantial numbers of private attorneys and provide services through pro bono as their principal means of service delivery. Excitingly, there were new state bar rules that took effect in July 2024 that allowed for greater flexibility for a QLSP to demonstrate that pro bono is its principal means of service delivery. So we just wanted to share with you. I'm going to fast track this, obviously. Time is of the essence. The GS committee already voted on the 14 applicants who applied through the narrative. This was all in your memo, and attachments to the GS committee's vote are all there and present for you. So just a highlight of the 2026 pro bono allocation applicants, because it is nice to know the effect of rules revisions that went into place. There were 21 total applicants, some in multiple counties, and this compared to 17 from last year. 8 were eligible through method 1, 14 applied through method 2. We won't go into any more of that. The full list is available as attachment E. And here is the recommendation that the GES committee, they reviewed the narratives and recommend for your approval.
I'll move the staff recommendation.
Second.
Did we get a motion and a second?
We did.
Yes. Okay, let's go ahead with the roll call.
Halagani,
Yes.
Babcock,
Abstain as to Public Law Center, yes as to all others.
Blakemore,
Yes.
Campbell,
Yes.
Galkin,
My abstentions from before are actually these ones, but it's Legal Aid Society, San Bernardino, and Riverside Legal Aid. Yes, it's still all others.
Gonzalez,
Yes.
Wong, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Zanville,
Yes.
Smith,
Yes.
Stalker,
Abstain as to capital pro bono and yes as to all the others.
Escobedo, Milrod,
Yes.
Al-Saraf,
Yes.
and Connolly.
Yes.
That's 14 yeses, 0 nos, and 3 abstentions. Motion carries.
All right, now I think we're ready to move. So we're going to move a voting item up one. We're going to do 6.4 on approval of 2026 partnership grants awards. First, before we jump into some of the updates, time providing. So you turn over to Michael Chong.
Good afternoon, Commissioners. My name is Michael Chong, Senior Program Analyst and Grant Lead for the 2026 Partnership Grants. And I have the pleasure of presenting on Agenda Item 6.4, approval of 2026 Partnership Grant Awards. This year, we received 43 applications with a total submitted funding request of about $8 million. The available amount for funding was $6 million, making this grant oversubscribed by over $2 million. Project requested funding amounts between $46,000 and $402,000. The Grant Eligibility and Support Committee utilized a scoring team comprised of 2 Legal Services Trust Fund commissioners and 3 State Bar staff. The scoring team held a calibration session and then proceeded to review all the submitted applications. The team discussed and scored each proposal. Scores ranged between 50 to 89 points out of a maximum 105. Average score was 73.4. 19 projects scored above 75. 7 projects scored between 70.1 and 74.9, 4 between 69.1 and 70, 5 between 65 and 69, and 8 below 65. At the July 25th GES committee meeting, they discussed funding recommendations for the award totaling $6,182,838. The GES committee reviewed several funding scenarios and used a similar approach as in previous years and is recommending to the Legal Services Trust Fund Commission the funding scenario as shown in attachment A in the agenda materials. The GES committee utilized a cut score of 65 points, which is lower than last year's 73 points, and initiated a funding ceiling of $250,000. Using a tier funding approach, projects scoring 75 points and up will receive 100% of the requests up to $250,000, with one caveat that the top scoring project will receive the $13,038 of remaining funds. Projects scoring between 70.1 to 74.9 would receive 95% of their requests, with one caveat. One project was allotted 100% of its requests as the initial amount requested was comparatively low. Projects scoring between 69.1 to 70 points would get 90% of their ask, and projects scoring between 65 and 69 would get 85. The number of projects recommended for funding this year with prior partnership grant awards is 23, and 12 projects are new. Of the 8 projects not recommended for funding, 5 had prior funding from PG. The recommended projects of funding will address 10 areas of law spanning 17 counties. And for comparison, this approach would fund 81% of the proposed projects as compared to 69% last year. It would also provide projects with more of their requested funding amounts by making the most reduced amount being 15% of their ask as compared to 29% last year. And I welcome any questions.
Thank you.
I just wanted, I had asked Michael some questions kind of late yesterday when I was reviewing things, and he was incredibly responsive and got me that information. So I wanted to just acknowledge I'm sure it was harder work to do it at the last minute. So I have 2 observations, which isn't about how I will vote for this, but when I was going through the review, I noticed that there were a number of organizations that had submitted multiple grant proposals. And this doesn't go to whether the grant proposals are terrific or not. I think almost every grant, the summaries I read were great for all of them. I think I'm a little concerned that 9 organizations are getting roughly half or a little bit more of the money, and or 60% of the total money. And some of that I think might be related to we're funding higher scoring applications at a higher level. So I would just encourage us to think about in the future how we might pay attention to the mostly larger organizations that are getting this very large amount of money and the impact that might have on smaller organizations. And then I had a chance to read Mental Health Advocacy Services letter that I think all of you got today. And I will just observe that I still think the definition of what's innovative could be considered. I know from representing mental health clients that it is innovative to provide in court a person that actually has the time to think of you. It is the only courthouse that I know of in California that has access to that service, and to see that that funding will continue, I think in large part because they didn't get either innovation or technology additions is a little heartbreaking to me. And I don't want to second guess what all of you did, but I do think it's important just to rethink the definitions and to pay attention to people with disabilities needs. Giving a person who has an intellectual disability or a significant mental health disability access to AI isn't really going to be a great solution to solving the problems. We're a person that can sit down with them in a calmer environment and help them be, and that to me is a definition and an accommodation for that type of disability. So thanks for letting me make the comments.
Thank you, Catherine. Go ahead.
Yeah, I also found compelling the letter from the Executive Director of Mental Health Advocacy Services. It's the services that clinic provides are fairly unique. And as Catherine said, by their definition, somewhat innovative. And I think one of the things that I understand, and I could be wrong in my understanding of this, but my understanding is that the scoring rubric somewhat changed with this particular year's application. Not true? Not correct. But then the scores changed in that one could get either 10, 15, or 5 or something like that. This is what I've been led to understand.
The scoring rubric is the same that it's been for the past 2 years, I believe, where each category does have different points based on if it meets, exceeds, or below. So in some of the rubrics, it's 20, 15, 10. Others, it's 15, 10, 5. So it's exact same rubric as the year prior.
Got it. Yeah, I think that as Catherine said, when we got some programs that are getting multiple grants, it just seems a shame that we're not able to fund a program that's providing a fairly well-needed service in an area that not many others are working in.
Thank you, Ken. Go ahead, Jason. Just a few things. One, I'll speak to the multiple awards for a single organization. So in years past, there have been instances where there have been grant applications for the same applicant where it's clear the application is for what is more or less the same program, just split off for a second courthouse or something like that. And I will tell you from past discussions for Partnership Grant Committee, which I used to be the chair of, or in evaluating, those were evaluated very critically, right? Because it looked through our lens as a committee, like this is one program, and you've just split it off in two, essentially to gain the competitive grant process. I will distinguish that kind of that perception of grant applications from what I saw, and Jody was part of the review team as well. I did not see that from the multiple grant applications from single applicants this time. I saw them as substantively distinct programs provided by or requested by an individual organization. So it did not appear to me as though they were deliberately attempting to game the competitive nature of the rubric, scoring criteria, evaluation process, or otherwise. And I highlight that because it is materially distinct from when we've seen it in the past. On the scoring, and this was in the letter we received, each year there's an application period, and it is a competitive grant process where we do, as Mike referenced, we have a group of staff and commissioners sit together and collaborate on trying to find what is a scoring calibration to figure out what the scores are and try to find a reasonable degree of consensus and balancing between staff perspective, commissioner perspective, really critically evaluating. And then each of us have to critically discuss okay, well, I gave it a 20 and Mikey gave it a 10. Let's talk about and debate why. And we go into detail in each of those. As a result, that an organization got a given score in 1 year and then repeated, despite being successful in their efforts, repeated substantively the same application again this year, does not presumptively entitle them to the same score. In fact, the scoring is done completely de novo. It's a fresh scoring evaluation. So it would be unfair to all of the others who are competing, especially new programs, to try to kind of give someone some level of precedent over their prior score.
And I understand that, and I respect that. I think that if that's the case, and I, like I said, I respect that decision. that ought to be made crystal clear to applicants, because I think as a prior applicant who received probably over the course of 23 years, I would say a total of maybe, I don't know, 20, 25 PGs for probably 6 or 7 different projects, multiple years of grants for different clinics that we did. Once we got to like year 2 or year 3, we kind of figured if staff hadn't raised a problem in a monitoring visit, that we were going to get re-upped. We knew we had to complete the application. We knew it was a competitive process, but we thought that, you know, things are going well and this is a valuable service for the court. And so the likelihood is we're going to get re-upped. And I think what, reading the letter, it seems like they made an assumption as to that which wasn't accurate and wasn't warranted. And if that's going to be the way to proceed, and again, I respect the committee's decision to proceed that way, I think that needs to be made very clear to applicants that prior success does not guarantee future success. Because I think once people get the funding in, say, year 2 or 3, they're thinking, oh, I'm fine for year 4 and 5. All I've got to do is fill out the same application I've been filling out. And that's clearly not the case.
Well, I think there, if you look at the scoring rubric or sit in a calibration session, there are significant advantages to having been a program that has been funded. Particularly, we see that a lot of those programs that have been funded tend to score better in their administration scores. They score better a little bit on the evaluation scores because they've gotten kind of their sea legs on how to manage the program. And their scores generally reflect, not always, sometimes there's exceptions, that they have that, you know, confidence in managing their program. Whereas new programs, by contrast, can struggle in those areas and tend to be much more likely to get a little bit of help in the, you know, there's the, you know, is it a new program? So there's a little bit of an incentive there. And that's a deliberate effort by the committee to try to basically have it be Kickstarter money for new programs to develop and expand. And that's also why there's a category for covering sustainability in funding. Because the hope is that these programs can leverage PG grants into being able to demonstrate the validity and importance of their programs, and then appeal to the greater, you know, philanthropic or otherwise funding sources to sustain it long term. That's not always the case, but that's one of the factors that we evaluate. And there are some scoring mechanisms, like in the rubric, where we tend to see they're like inversely proportional. Like as someone goes up in here, they tend to, you know, the score drops a little bit on the other side, and vice versa. But it is a balancing act that we try to do. I appreciate your comment that we want to make it crystal clear that past success in your scoring is not necessarily a guarantee of future scoring success, especially because if there's greater applicants, or those applicants have far more impressive applications this go around and limited funding, then we can have a different cutoff, as we've had for a few years, where we are oversubscribed, I think is the word you used, where it's like, well, we need to make the cut somewhere, or underfund projects a different way. And yeah, there's no perfect way to slice that. But that is a challenge. I don't know if it's specifically the innovation aspect of this particular program that, you know, to go to the public comment, that was the reason why it didn't score well enough to hit the cutoff. In fact, I think their request said, adjust our score upwards in this category and then move the cut point down. Another way of looking at that is keep the cut point the same and increase our score that much more to pass the cut. So I think the ask is quite a big shift from where the current cut point is.
Yeah, I think that's why, at least for me, I'm talking about some things we can look at prospectively.
Right.
And, you know, the example might be with, like, it is unusual that we've been able to fully fund grants. We funded a whole bunch fully, but I do think there's value, particularly for groups that are getting multiple grants to think about, like, could we spend some of those funds with a reduction there to fund some additional grants? And that is not saying fund a specific grant. Those are two very different things.
Thank you, guys. In the interest of time, and somehow we got into 12 minutes before 4 o'clock, so we've got a lot to accomplish.
Because you got a lot of GES.
Yeah. I think the discussion's been robust, and that's why I wanted to continue. But I'm going to let Erin go ahead, and then Kim's got her hand up, and then we can get to a motion and see if we can fit in 1 or 2 more of the agenda items before we break.
Yeah, thank you. And I'll try to be brief because I also just share, I guess, disappointment that this particular project will be funded, as well as I'm sure others that were also meritorious. But to the point, which I think is well taken in the public comment, that this is the only project on the mental health and especially the care court, which in my current role, writing bench books for judges, they're desperate for guidance on the care court. So it really is a shame to shut down the only clinic in the state that is creating, self-help materials and guidance on that, which really could be replicated across the state, and I think help the whole field and the bench, frankly. So it's disappointing, and I guess I would maybe echo Catherine's comment that going forward, it would be nice to relook at the rubric here, and whether it's innovation or whatnot, or add a category or something, so that there can be maybe a more holistic look, not only at the distribution across organizations and size of organizations, but the subject area, right? So if we have, and nothing against, I'm a DV person, so I'll just put DV, if there's 10 DV proposals, I'm sure they're all valid, right? And needed. But if we have 10 DV proposals and no care court, like, how do we want to, as a commission, approach that scenario? Because I think that is where we are. And I also respect, the committee's scoring and, diligent, adherence to consistent standards and all that. But I think this is an unfortunate situation.
Kim?
Hi, I just wanted to let you know that Jody Pryor has joined the meeting as a public member.
See, Jody, you've got your hand raised. Do you want to go ahead?
Thank you. I just wanted to, I wholeheartedly agree with Jason's comments, but just to add one point is, we did do the calibration session, and we spent a lot of time really making sure that our scores were consistent among all the applications. And we would go back and make sure we were really giving the same credit to all the applications. So I think to reevaluate one would be really do a disservice and be unfair to all the other 42 applications, and that we would have to look at everything again to make sure that our scores were consistent across all the applications. And then I did want to add that we didn't just look at innovation with technology. We did look at, is this a new service methodology? Is someone doing something different? So I just wanted to add that point as well.
Thank you, Jody. All right. Do we have a motion? Somebody want to make a motion on this?
I can read the resolution.
Yeah, that'd be great. Yeah.
So the resolution is, should the LSTFC concur, it is resolved that the Legal Services Trust Fund Commission approves the Grant Eligibility and Support Committee's funding recommendation for the 2026 Partnership Grant Awards, as described in the committee's memo dated August 8th, 2025, including attachment A.
Okay, thank you. Does somebody want to make that motion?
I will make the motion.
Jason moves. Do we have a second?
I'll second.
Vanetta seconds. Now let's do a roll call vote.
Alakani,
Yes.
Babcock,
No.
Blakemore,
She stepped out. She stepped out.
Yeah. Campbell,
Yes.
Falcon,
Yes, but I have to abstain for like 10 of them. So I'm just going to defer to Mikey to have the record of it.
thank you. Gonzalez,
Yes, but abstain as to Legal Access Alameda, Legal Assistance for Seniors, and the Family Violence Law Center.
Long, King,
Yes.
Judge Klein, Mahoney, Morales, Pryor, Judge Rosie,
Yes.
Sandville,
Yes.
Smith,
Yes.
Stalker,
Yes.
Escobedo, Milrod,
Yes.
Alsteroff,
I'll abstain as to Legal Aid Foundation of Los Angeles, otherwise, yes.
Oh, excuse me, I've got to abstain as to CCLS.
got it. And Connolly?
Yes.
That's 12 yeses, 1 no, and 4 abstentions. Abstentions. Motion carries.
Okay, thank you. We've got a few more updates that are on the agenda and only 7 minutes until the end. I'll sort of defer. I don't know if we want to race through CalHFA 2.
Yeah, can I make a suggestion? Yeah, can we do
Yeah.
CalHFAs just so the commission knows that money's coming through? We will skip justice gap study and figure out a way to get that information to you, or put it on the next agenda item. And then we should also do our liaison reports.
That's great. So I'll turn it over to Mara. Thank you.
Thank you so much. I will be incredibly brief. I'm Mara Vide, Senior Program Analyst and CalHFA Grant Lead. We are going to have a CalHFA 2 grant. We are very excited about this prospect. The CalHFA 2 grant will be for $24 million with up to 8% for state bar administrative costs. It will be focusing on preserving home ownership and protecting home equity. In addition to that, it's going to have a really unique component in that it will be soliciting applications for fellowships as a part of this grant. I know that the PowerPoint was included to you along with the rest of the meeting materials. And if you have any questions, please do feel free to reach out. I would also like to solicit volunteer scorers for the CalHFA 2 grant applications. We'll be scoring applications between September 22nd and October 10th. So if you are available to participate in the scoring process for this new grant, please reach out to me. It would be wonderful to have you. Thank you so much.
Or you can email me and I'll forward it to Mara if you don't have Mara's contact.
Terrific. Thank you. Okay, then I'll turn it to Melanie for the Judicial Council report.
Sorry, I was trying to be right quick. Good afternoon. My name is Melanie Snyder, and I am the liaison for the Judicial Council of California. I'm a supervising attorney in the Center for Families, Children, and the Courts. And I will be as quick as I can be. Wanted to let you know that the Judicial Council approval for the distribution of funds for the EAF, IOLTA, and Partnership Grant, our requests are moving through the process. Next, they will go to the Advisory Committee on Providing Access and Fairness, who will provide our recommendation to the Judicial Council so that we can distribute the funds, and the council meeting is set for October 24th. We're also at the same time, we are not waiting for that approval. We've started drafting the contracts so that we can get that money to you and you can get it out to your programs as quickly as we possibly can. So we've got a new contracting process. It's sort of going to make things a little bit longer on our end, but we should still be ready to get right into the branch accounting and procurement negotiations with the bar as soon as the meeting's over on October 24th. So we're right in line with that, and you should be able to expect your funding in a very timely manner. I wanted to also let you know that we're getting ready to launch a new grant cycle for the Shriver grants, for the Sergeant Shriver Civil Implementation Committee grants, and they will go out sometime in the fall. And it's often the same, our same programs overlap, and we provide funding. So if you have an opportunity, please let others know to start looking in the fall for our application. And then the last thing is we are beginning to look at the nominations process, and thank you, Dwan, for making mention of this at the beginning of the meeting. We are going to meet next week and begin to make sure that we're continuing to keep our nominations for your committee flowing, and that we keep commissioners on board for you. So that is my report, and thank you very much. I'm sorry, are there any questions? Okay, thank you very much.
Thank you, Melanie. Thank you very much, Melanie. Selena.
Well, I promise to be even quicker.
I think I said in a subcommittee meeting, just a quick update, that we are currently planning our deputy director retreat. We do this in partnership with One Justice, and it is heavily subsidized by funding from this committee. We have done outreach to the new IOLTA applicants as well, because we think it's really important for folks to get connected as early as possible. I think our communities are very, very supportive of each other, especially in this time of budget uncertainty. So the deputy director retreat will be in September. Our executive director retreat, I think, will return in the spring. We also are coordinating communication staff across the state. We've been doing this now for a few months. We used to do coordination nationally with Voices for Civil Justice. That organization's no longer around, so we have been trying to coordinate communication staff here in California. And then just a very brief thank you. We did a presentation, I want to say last week now, I can't remember, maybe Monday of this week, on our summer fellowship for law students. And we actually used, the camera's up here. We actually used data from the State Bar, because you fund the Legal Aid Leaders Fellowship, which is your summer law student funded project. And we use some of your data just to show why it's so important to pay law students over the summer. So that presentation was live. We had a lot of organizations who were there to learn about what law students accomplish over the summer. And time and time again, I talk about how important it is to pay law students so that we can increase our pipeline. So I was happy to have y'all's data to be able to show why it was important. And that's it.
Okay, thank you, Selena. We've got 1 minute. I want to say thank you to everybody for the level of discussion that we had today. I think it was, I was actually expecting that we would be, early on in the meeting, that we'd be well ahead of time, and then we just made it into less discussion, and that obviously turned into us racing at the end. But I think it was valuable. I think it was a really good indication of kind of the way that our commission runs and the way that we handle these very significant issues. So I appreciate that. I appreciate that we reached a consensus on these matters, and have plans going forward to address some of the concerns that we have. So with that, thank you all. Look forward to seeing you at our next meeting, which is November 7th, and that's going to be a Zoom conference. And with that, the meeting has ended. Have a great weekend.
Well done, you.
Right on time.